Good morning, everybody. Happy Wednesday. Welcome to TCF Live. Good to have you here. Let's get our day started in Allegan County, Michigan. This is Judge Skocelas.
Committed or attempted by another person, contrary to state law. It's a charge of interfering with making a crime report. This charge is a misdemeanor charge, carries a maximum penalty of a year in the county jail and a $1,000 fine. A consecutive sentence may also be imposed to any other conviction. Count 2 is a charge of domestic violence, and it states on the same date, same location. You did assault or assault and batter Ebony Sue Bowen, your wife, contrary to state law. Domestic violence is also a misdemeanor charge. It carries a maximum penalty of 93 days in jail and a $500 fine. In addition to that, if you are convicted of this charge, you'll no longer be able to own or possess firearms for at least the next 8 years. So, Mr. Bowen, you have 2 separate criminal charges in this case. Do you understand both of these charges?
Yes, sir.
You wish to enter pleas of not guilty or guilty to these 2 charges?
Not guilty.
When not guilty, please set this for a jury trial. Indicate you retain counsel in this case. Court file shows you released in the Allegan County Jail on a $500 personal recognizance bond. This is a protective bond. Will continue bail in that amount with the same conditions until further order of the court. Your case will be set first for pretrial conference with the prosecutor's office, then for jury trial in this courtroom, District Courtroom A. Court staff will send to you and to your attorney the date and time of your next court appearance. So with that, you are free to hang up from the court proceeding this morning. Be expecting that in the mail, okay?
Your Honor, can I just make a quick request with regard to the bond conditions?
I have no prosecutor here, unfortunately, at arraignment, so ex parte, no.
Thank you, Your Honor. We will reach out to the prosecutor's office or file a motion. Thank you.
Thank you.
Josh, I will call you. You can hang up.
All right.
Mr. Badger, were you all set with everybody else?
Yes.
All right, let me pull that in 1 second.
Can you guys hear me?
Yep, 1 moment. We'll be right with you.
Sorry, I didn't hear anything, so I was making sure.
And good morning. On the record, first on file 260069FY, People versus Cesar Alejo Guerrero. Here this morning for arraignment, charged through a felony complaint issued by the Allegan County Prosecutor's Office on a charge of possession of cocaine.
Huh?
Mr. Badger, please.
Hello?
Good morning, Your Honor. Sam Badger
Hello?
appearing on behalf of Mr. Alejo Guerrero for the limited purpose of arraignment. We have reviewed the charging document and waive its formal reading. He does qualify for a court-appointed attorney. We request that this matter be set for a probable cause conference and a preliminary examination, Your Honor. Thank you.
Again, sir, this is a felony charge, and in district court, you are entitled to a preliminary examination on a felony charge. As required, we are going to set that for you within 2 weeks. Your probable cause conference is a week from tomorrow, April 23rd, and that will be at 1 p.m. in this courtroom, District Courtroom A. Your preliminary examination itself is the following Wednesday, April 29th at 9 a.m., also in this courtroom, District Courtroom A. Bail was set at warrant authorization at $1,000 cash or surety. Court file shows you posted a $1,000 surety bond. Bail will be continued in that amount with the condition you not possess or consume any alcohol, marijuana, or illegal controlled substances while your case is pending. The Public Defender's Office has determined you are indigent, and they will be appointing an attorney for you at public expense. So an attorney from the Public Defender's Office will discuss your case with you at your next court appearance. Again, your next court appearance is a week from tomorrow at 1 o'clock in the afternoon. So you are free to hang up from the court proceeding today. Be expecting contact next Thursday afternoon from an attorney from the Public Defender's Office, okay?
Okay, thank you.
260905 SM, People versus Ashley Renee Deming. Here this morning for arraignment charged through a misdemeanor complaint issued by the Allegheny County Prosecutor's Office on a charge of domestic violence. Mr. Badger, please.
Thank you, Your Honor. Sam Badger appearing on behalf of Ms. Deming for the limited purpose of arraignment. We have reviewed the charging document and waived its formal reading. She's entering a plea of not guilty and does qualify for a court-appointed attorney. We request that this matter be set for a pretrial and a jury trial, Your Honor. Thank you.
We'll enter a not guilty plea, set this for a jury trial, indicate you're requesting an attorney at public expense. Court file shows you released from the Allegheny County Jail on a $500 personal recognizance bond. This is a protective bond. We'll continue bail in that amount with the same conditions until further order of the court. Your case will be set first for pretrial conference with the prosecutor's office and then for a jury trial in this courtroom, District Courtroom A. The Public Defender's Office has determined you are indigent and they will be appointing an attorney for you at public expense. So an attorney from the Public Defender's Office will discuss your case with you at your next court appearance. Your next court appearance date will be sent to you by the clerk's office in the mail. So you are free to hang up from the court proceeding this morning. Be expecting your next court appearance date in the mail, okay? About 260935 FD, People versus Rocky, Travis, Levi, Ellis. Here this morning for arraignment charged through a felony complaint issued by the Allegheny County Prosecutor's Office on a charge of operating while intoxicated, third offense. Count 2 is a misdemeanor charge of having additional open alcohol within the motor vehicle. Count 3, a misdemeanor charge of driving while license suspended, second or subsequent offense. Mr. Badger, please.
Thank you, Your Honor. Sam Badger appearing on behalf of Mr. Ellis for the limited purpose of arraignment. We have reviewed the charging document and waived its formal reading. He does qualify for a court-appointed attorney and we request that this matter be set for a probable cause conference and a preliminary examination, Your Honor. Thank you.
Count 1 is a felony charge. In this court, you are entitled to a preliminary examination on a felony charge. As required, we are going to set that for you within 2 weeks. Your probable cause conference is a week from tomorrow, April 23rd, and that will be at 1 p.m. in this courtroom, District Courtroom A. Your preliminary examination itself is the following Wednesday, April 29th at 9 a.m., also in this courtroom, District Courtroom A. Bail will set a warrant authorization at $5,000 cash or surety. Court file shows you posted a $5,000 surety bond. Bail will be continued in that amount with 2 conditions. First, that you not drive until you obtain a valid operator's license from the Michigan Secretary of State. Next, that you not possess or consume any alcohol, marijuana, or illegal controlled substances while the case is pending. Public Defender's Office has determined you are indigent and will be appointing an attorney for you at public expense. So an attorney from the Public Defender's Office will discuss your case with you at your next court appearance date. Again, your next court appearance date is a week from tomorrow at 1 o'clock in the afternoon. So you are free to hang up from the court proceeding today, okay? I have 2 files on Brian Darnell Hunter, 260911 SD, 260912 ST. A civil infraction file under 26 SD 43479 CSI. All 3 files are based on the same citation. It was issued by the Allegheny County Sheriff's Department on charges of operating while intoxicated, second offense, driving while your license was suspended, and a speed violation. Mr. Badger, please.
Thank you, Your Honor. Sam Badger appearing on behalf of Mr. Hunter for the limited purpose of arraignment. We have reviewed the charging document and waived its formal reading. He is entering pleas of not guilties to the misdemeanors, and he will also be denying the civil infraction at this time. We request that these be set for a pretrial and a jury trial. And he does qualify for a court-appointed attorney as well. Thank you, Your Honor.
The charges of operating while intoxicated, second offense, and driving while your license was suspended will enter not guilty pleas. Set these for jury trials. Indicate you're requesting an attorney at public expense. Court file shows you're released from the Allegan County Jail on the first file on a $500 personal recognizance bond, and on the second file on a $300 personal recognizance bond. Bail will be continued in those amounts with conditions as follows. First, that you not drive until you obtain a valid operator's license from the Michigan Secretary of State's office. Next, that you not possess or consume any alcohol, marijuana, or illegal controlled substances while the case is pending. Both of these two cases will be set for pretrial conferences with the prosecutor's office and then for jury trials in this courtroom, District Courtroom A. The public defender has determined you are indigent. They will be appointing an attorney for you on these two cases at public expense. So an attorney from the public defender's office will discuss your cases with you at the date and time of your pretrial conference. The speed violation is a civil matter. You'll be representing yourself on that case, as the public defender's office will not be representing you. I will enter a denial on that charge. This will also be set for a pretrial conference with the prosecutor's office, and the date and time of that will be sent to you by them as well. So with that, at this point, you are free to hang up from the court proceeding. You're going to get dates and times for pretrial conferences on all three of these cases sent to you by our clerk's office in the mail. Okay. File 260943 SD, People versus Angelica Marie Huntington. Here this morning for arraignment, charged through a citation issued by the Allegan County Sheriff's Department, the charge of operating while intoxicated. Mr. Badger, please.
Thank you, Your Honor. Sam Badger, appearing on behalf of Ms. Huntington for the limited purpose of arraignment. We have reviewed the charging document and waived its formal reading. She's entering a plea of not guilty and does qualify for a court-appointed attorney. We request that this matter be set for a pretrial and a jury trial, Your Honor. Thank you.
What are not guilty pleas? Set this for a jury trial. Indicate you're requesting an attorney at public expense. Court file shows you released from the Allegan County Jail on a $500 personal recognizance bond. Bail will be continued in that amount at this time. Condition of your bails, you not possess or consume any alcohol, marijuana, or illegal controlled substances while the case is pending. Your case to be set first for a pre-trial conference with the prosecutor's office, and then for a jury trial in this courtroom, District Courtroom A. Public Defender's Office has determined you are indigent, and they will be appointing an attorney for you at public expense. So an attorney from the Public Defender's Office will discuss your case with you at your next court appearance date. Your next court appearance date is going to be sent to you by the clerk's office in the mail. So at this point, you are free to hang up from the court proceeding. The court staff is going to mail your next court appearance date to you in the mail. And I'm sure this is not the way you wanted to start the day, but happy birthday.
Thank you, Your Honor. I know it is not, but I understand.
You're all set today. Hope the rest of your day goes better.
Thank you.
File 232268 FY, People versus Jason Robert Maynard. Matter set this morning for arraignment, charged through a felony complaint issued by the Allegan County Prosecutor's Office and a charge of possession of methamphetamine. Sir Badger, please.
Thank you, Your Honor. Sam Badger, appearing on behalf of Mr. Maynard for the limited purpose of arraignment. We have reviewed the charging document and waive its formal reading. Mr. Maynard will be does qualify for a court-appointed attorney. We request that this matter be set for a probable cause conference and a preliminary examination, Your Honor. Thank you.
And this is a felony charge, and in district court, you are entitled to a preliminary examination on a felony charge. As required, we are going to set this for you within 2 weeks. Your probable cause conference is a week from tomorrow, April 23rd at 1 p.m. in this courtroom, District Courtroom A. Preliminary examination itself is the following Wednesday, April 29th at 9 a.m., also in this courtroom, District Courtroom A. Bail is set at warrant authorization at $5,000 cash or surety. Court file shows you posted a $5,000 surety bond. Bail will be continued in that amount with the condition that you not possess or consume any alcohol, marijuana, or illegal controlled substances. The public defender's office has determined you are indigent. They will be appointing an attorney for you at public expense. So an attorney from the public defender's office will discuss your case with you at your next court appearance date. Again, your next court appearance date is a week from tomorrow at 1 o'clock in the afternoon. So you are free to hang up from the court proceeding this morning, okay? File 260954 SD, People versus Spencer Michael Murphy. Here this morning for arraignment charged through a citation issued by the Gun Lake Tribal Police. This is on a charge of operating while intoxicated while having a high blood alcohol content. Mr. Badger, please.
Thank you, Your Honor. Sam Badger appearing on behalf of Mr. Murphy for the limited purpose of arraignment. We have reviewed the charging document and waive its formal reading. He is entering a plea of not guilty and does qualify for a court-appointed attorney. We request that this matter be set for a pretrial and a jury trial, Your Honor. Thank you.
Will enter a not guilty plea, set this for a jury trial, indicate you're requesting an attorney at public expense. Court file shows you were released from the Allegan County Jail on a $500 personal recognizance bond. Bail will be continued in that amount. Condition of your bail on this charge is that you not possess or consume any alcohol, marijuana, or illegal controlled substances while your case is pending. Your case will be set first for a pre-trial conference with the prosecutor's office and then for a jury trial in courtroom D. Public defender's office has determined you are indigent. They will be appointing an attorney for you at public expense. So an attorney from the public defender's office will discuss your case with you at your next court appearance date. Your next court appearance date will be sent to you by the clerk's office in the mail. So you are free to hang up from the court proceeding this morning. Be expecting that in the mail, okay? File 260906 SM, People versus Anna Marie Rankin. Here this morning for arraignment charged through a misdemeanor complaint issued by the Allegan County Prosecutor's Office on a charge of domestic violence. Mr. Badger, please.
Thank you, Your Honor. Sam Badger appearing on behalf of Ms. Rankin for the limited purpose of arraignment. We have reviewed the charging document and waive its formal reading. She's entering a plea of not guilty and does qualify for a court-appointed attorney. We request that this matter be set for a pretrial and a jury trial, Your Honor. Thank you.
Under a not guilty plea, set this for a jury trial, indicate you're requesting an attorney at public expense. Court file shows you released from the Allegan County Jail on a $500 personal recognizance bond. This is a protective bond. Will continue bail in that amount with those same conditions until further order of the court. Your case will be set first for a pretrial conference with the prosecutor's office and then for a jury trial in this courtroom, District Courtroom A. The public defender has determined you are indigent and they will be appointing an attorney for you at public expense. So an attorney from the public defender's office will discuss your case with you at your next court appearance. Your next court appearance date will be sent to you by the clerk's office in the mail. So you are free to hang up from the court proceeding this morning. Be expecting that in the mail, okay?
Thank you.
File 260948 SD, People versus Richard Rukundo, this morning for arraignment charged through a citation issued by the Allegan County Sheriff's Department in charge of operating while intoxicated. Mr. Badger, please.
Thank you, Your Honor. Sam Badger appearing on behalf of Mr. Rukundo for the limited purpose of arraignment. We have reviewed the charging document and waive its formal reading. He is entering a plea of not guilty and does qualify for a court-appointed attorney. We would request that this matter be set for a pretrial and a jury trial, Your Honor. Thank you.
Under not guilty plea, set this for a jury trial. Indicate you're requesting an attorney at public expense. Court file shows you're released from the Allegan County Jail on a $500 personal recognizance bond. Bail will be continued in that amount with a condition that you not possess or consume any alcohol, marijuana, or illegal controlled substances while your case is pending. Your case will be set first for a pre-trial conference with the prosecutor's office, and then for a jury trial in District Courtroom D. Public Defender's Office has determined you are indigent, and they will be appointing an attorney for you at public expense. So an attorney from the Public Defender's Office will discuss your case with you at the date and time of your next court appearance. Your next court appearance date will be sent to you by the clerk's office in the mail. So you are free to hang out from the court proceeding this morning. Be expecting that in the mail, okay? File 260083FY, People versus Daniel Christopher Berry. Matter was set this morning for arraignment. This is on a felony complaint issued by the Allegan County Prosecutor's Office on a charge of unlawfully driving away of a motor vehicle. A notice to appear was sent by the clerk's office on March 31st. It was for today's date at 8:30 in this courtroom. He was given permission just to call in via Zoom. It is now 9:02 a.m. We've had no contact from him. Court file shows a prior bench warrant was issued in this case. And take that back. That was not a bench warrant. That was an actual bond posted, it looks like, on the original charge. So there was a $1,500 cash bond posted, but that was on the original charge. Do not see any prior bench warrants in this case. And accordingly, we will hold this for a matter of 48 hours before any bench warrant is issued. File 260945 SD for People versus Hilario Lopez Juarez. Matter was also set this morning for arraignment at 8:30. Notice to appear was set on the 30th of March for today's date. At 8:30, was also given permission to call in via Zoom. It is 9:03. We've had no contact with him. This is also a non-assaultive offense. Do not see any prior non-appearances. We will also hold this file for a period of 48 hours before any bench warrant is issued. Robbie Allen Street, 260923 SM and X4669098 ST. Both were set this morning for arraignment at 8:30. Notice to appear sent by the clerk's office on March 26th for today's date. Given permission to call in via Zoom. It is now 9:04. We've had no contact with him. Neither of these charges are assaultive offenses. Do not see any prior non-appearances. We will also hold both of these files for 48 hours before any bench warrant is issued. And that concludes our 8:30 arraignment document.
Well, there you go, everybody. Good morning once again. Welcome to TCF Live. My name is Dan Soul, your guide through this morning's journey through Courtlandia. Hope you're all having a good day so far. Let's do something different. Let's go to Ohio, but let's go to Licking County. This is Judge David Stansberry.
He does.
And you
It's going to be a guilty plea, Your Honor.
It's going to be a guilty plea today?
Yes, Your Honor.
Okay. Do you acknowledge receipt of the citation?
We do.
Do you wish to have it read?
No.
Okay. So, Mr. Hernandez, your attorneys indicated that you wish to enter a plea of guilty today. Is that correct?
Yes, sir.
All right. So, a few things we need to go over. The first of which is you are presumed to be not guilty, and you don't have to plead guilty. Nobody can force you to do that. Do you understand?
Yes, sir.
You're presumed to be not guilty until and unless the state of Ohio could prove your guilt beyond a reasonable doubt. Are you aware of that?
Yes, sir.
You have a right to a trial, and in your case, that could be with a judge or a jury. Did you know that?
Yes, sir.
Did you also know that at the trial, you could both cross-examine your accusers and also subpoena your own witnesses to compel their attendance at trial? And you wouldn't have to testify at the trial if you didn't want to, and the decision not to take the witness stand cannot be held against you in any way. Do you realize that?
Yes, sir.
By pleading guilty, however, you admit to committing the offense of operating a vehicle while impaired. That means you're giving up your presumption of innocence. The state no longer has any burden to prove anything in order for me to find you guilty. and you'll waive your right to a trial and the other rights that were discussed in that video presentation. Do you realize that?
Yes, sir.
And if I accept your plea and enter a conviction, I'm going to impose sentence upon you. Ms. Fraser, the citation indicates that there was a prior in 2025. I'm assuming that's out of state.
It is out of state and it's not actually a prior, it's still pending technically.
Okay.
So technically it's still a first. To my knowledge. And I spoke with his Texas attorney and that's what I also was told.
Always tricky when it's out of state.
I know. Do you have that court on that?
Here we go. So it looks like it's from November.
He hasn't even had court, I don't believe.
I haven't had a court date appointed or anything for that yet.
According to what I have here, it's a felony offense.
Oh, sure.
That's because apparently it's basically the Texas equivalent of our child endangering based on
Got
OVI.
it.
But if this is a first offense within a 10-year period, Mr. Hernandez, you face up to 180 days in the jail, up to a 3-year suspension of your license, and a fine not to exceed $1,075. Do you understand?
Yes, sir.
At a minimum, the court's required to fine you $565, suspend your license for at least 1 year, and sentence you to serve 6 consecutive days in Licking County Jail. The alternative to that is I can order that you successfully complete a 3-day drive intervention program, which would count towards 3 of those 6 days, but would leave you 3 actual days to serve. And you are eligible to ask the court to grant you what are called unlimited driving privileges, which would result in no actual jail time being imposed up front. But if you were to violate the rules that go along with unlimited driving privileges, the court has absolutely no discretion but to force you to serve the entire balance of a suspended sentence. So if I gave you a 180-day suspended sentence and you asked for unlimiteds, I suspend the whole thing, but if you screw it up, you serve 180 days. Do you realize that?
Yes, sir.
All right. Now, have you been subjected to any threats, promises, or offers of reward to get you to do what you're doing?
No, sir.
Are you under the influence of any alcohol or illegal drugs?
No, sir.
Do you take any medications that affect your ability to understand what's going on around you?
No, sir.
Are you satisfied with the advice and representation you've received from your counsel?
Yes, sir.
And are you a citizen of the United States of America?
Yes, sir.
Very well. Court finds that the plea and waivers have been knowingly, intelligently, and voluntarily made. I'll accept the plea and enter a conviction. He's actually charged with an A1A.
That's what I was about to say.
Sure. Now, Ms. Fraser, what would you like to say on behalf of your client?
Thank you, Your Honor. Mr. Hernandez would be willing to, if the court would follow along with the minimums on the A1A, he's willing to do the jail time basically immediately. He's supposed to go back to Texas whenever he can. His child of his mother is here to help facilitate him getting back to Texas. So we just asked the court to give him time to pay. He does not live here. He was here temporarily for a job. And if the court wants to impose a probationary period, we would ask for a non-reporting. That way, he doesn't have to keep flying back here. But yeah, he is willing to serve the jail time, basically, whenever.
All right, thank you, counsel. Mr. Hernandez, you have a right to speak. Is there anything you'd like to say on your own behalf here?
No, sir.
Was this a work vehicle or your vehicle?
My view.
It's totaled.
Yes, ma'am.
And where exactly in Texas is Hamlin?
Hamlin is about 30 minutes northwest of Abilene, Texas. It's the closest big town. More west Texas.
All righty. So you're saying, Ms. Fraser, that if the court were to go along with your request, your client is prepared to begin serving his jail term today?
Yes, Your Honor. You have your inhalers and stuff, correct?
Yes.
Okay. Then yes, Your Honor. Do you need time to pay fines and purpose?
Yes.
All right, very well. I'm going to go along with the request of your attorney here, Mr. Hernandez, and I'm going to send you to serve 3 days in jail. I'll impose a $565 fine as well as costs. And just so the state gets its pound of flesh, I'm going to make it a 2-year license suspension. Now, that can be reduced to 1. I'm not saying I will, I'm not saying I won't, and it could have been 3. But given the fact that you have one pending that's a felony in Texas and the test result here, the court finds that that's appropriate under the circumstances. Now, you'd be eligible to ask the court for limited driving privileges. How that's going to intersect with what Texas will do, I don't know, but our Bureau of Motor Vehicles will notify your Bureau of Motor Vehicles of what this action this court has taken. So, listen, I'm not a clinician, I'm not a substance abuse counselor. I've been doing this for 30 years, and the best definition I ever heard was from a guy I represented about 20 years ago, and he said, if something causes you a problem, then it's a problem. This is a problem, and you need to deal with it, because otherwise this is going to be the first of very many occasions that you're going to find yourself in front of a judge having to listen to them talk. You understand that?
Yes, sir.
How old is your child?
4 and 5.
Okay, so you have a greater responsibility than just going out and having fun.
Yes, sir.
You will get time to pay. You're going to be taken into custody and transported to the Justice Center. You'll be released in 72 hours. Do you have any other questions?
No, sir.
Anything further, Ms. Fraser?
I think
Can I
we're,
say
You may go
goodbye
to-
to mine, please?
Go with the bailiff.
do you want these for that file?
Yeah, I mean, usually it's not really a change of plea so much as it's just
That's
entering a
fine.
guilty plea.
That's fine,
Thank
thanks.
you.
Okay, friends, let's move from Ohio up to Michigan. We'll say good morning to Judge McNally.
Anything you'd like to say? No, yeah. I didn't like some of this that I read in the board. I'm not saying it was you. You were supposed to tell the police officer that you had a firearm immediately upon him stopping the car. You didn't have a CPL. And your buddy here, whoever he is, I don't need to go into it. I don't know if he was in here on another case. Wow. Didn't obey lawful commands, acting like he was sleeping. Who does this guy think he is? Is this the kind of people you're gonna hang out with? I mean, I'm just asking you, if you're gonna hang out with them, listen, if you're gonna hang out with guys like this, you're not gonna do any good. Okay, I'm just telling. You wanna hang out with guys like that think they can disrespect police officers. You know, there were guns in the area, right? Yeah. And he's refusing lawful commands, and you hang out with guys like this, you'll be back here by, I don't know, today's April 15th, you'll probably be back in here by the 20th. I'm serious. You tell him I said that. Was he in front of me on any of this? You guys got Glocks for. What did you have a Glock for?
I did bought it from my friend.
Bought it for your friend. From your friend. What are you gonna do with a Glock? What do you need a Glock for?
Like guns.
Like guns. I just didn't like this. This struck me wrong. I'm reading how disrespectful this buddy of yours was, and I don't know who he thinks he is. He must be running the Pentagon at a minimum. You're not smirking, are you? Because I don't find any of this amusing. Pardon?
No, I'm not smirking.
Are you working now?
Yeah, I go back to 20.
Who's this with you?
Like,
I hope you're paying him rent.
yo, I give him my house.
You what?
I gave him my house. Yeah.
You gave him your house?
Yeah, but he didn't put me in cleaning. But the house, I've turned over to him.
Why?
Cause I want to set him up in life. I've already discussed his friends with him.
I had great grandparents too. They were phenomenal. Nobody gave me their house though.
Me either.
I'm telling you. I just don't like some of the things I write in this report. And you are a young man, you're 19 years old, you have a chance to keep this off your record. I hope you do. I hope you think about what I'm telling you. If my father used to tell me, if you sleep with the pigs, after a while, you start to smell like them. Got it? 9 months probation. You cannot leave the state without the consent of the court or violate any law or ordinance. If you change your address, place of employment, or home telephone number, you must notify probation. You have to report as directed. No firearms. No firearms. You're not to possess firearms. You're not to possess dangerous weapons. Do we understand?
Yes.
You're to obtain and maintain employment and provide proof of that. You're to attend a Class A training center, rights and responsibilities, weapons program. Attend that, complete that. I want you to serve 3 days on the court work program. That's $105, 35 a day. 200 fines, 75 costs, 75 victims' rights fee, $50 justice assessment. $400, screening fees 60 for 460, probation fees are 180 for 640 plus your court work program fees, 745. If you violate, your probation could be revoked. You could be incarcerated for 90 days. You have 21 days to appeal and 14 days to apply for a court-appointed lawyer for purposes of appeal. I'm going to give you a review hearing date. If you're compliant, you come back. I'll be more than happy to dismiss your case, okay? We'll give you a review hearing date, and that'll be on motion to the prosecutor. So I'll take this under height at you. Heather, what do you have for me? So 9 months, we're looking somewhere around the early part of January, I suppose, or late December.
So we could either, we have December 23rd if we want to do late December.
That's fine. December 23rd at 8:30. December the 23rd of 26 at 8:30. You have 21 days to appeal, 14 days to apply to a court-appointed lawyer for purposes of appeal. If you violate, your probation could be revoked, conviction entered, you'd be subject to a 90-day jail term. Do you understand that?
Yes.
All right. Any questions?
No, sir.
Can you pay all of this?
He can't pay it all day. We proposed that he pay $20 a month, starting May the 1st.
Judge, he does have a bond, and then he does have an additional bond that we transferred over from another case.
He has a
of his.
bond because he didn't show up. How much is this bond's worth?
He has a $300 bond on this case, and then a $180 bond we transferred from another case.
Was that was 2,010% on that one? It's
Correct.
3,010% on this, right?
Correct.
So he has $500. That means he has $450 to apply. And that's all in his name?
I believe so. Let me just double check that real quick.
Yes, at least mine is. The one on this case is.
Yes, they are. Both
You
are.
pay $450 now, and I will simply give you until how long to pay the other $295?
You pay that on May 1st, May 1st, Your Honor.
May the 1st. All right, you'll meet with probation. You'll get your review hearing date. Stay out of here. Good luck. Thank you.
Thank you.
All right, we need Beth on that, Christina.
What's the last name?
What do you have, Mr. Kaylee?
Justice?
Christina Justice. Christina Love Justice, 26W839416. Is this your client? What case do you have, Mr. Kaylee?
No.
I'm having a hard time picking you up. I'm not getting you at all.
Not getting me?
What case? What is it?
Well,
It is scheduled at
9:15.
Your name, ma'am?
Yeah, justice.
This is 267839416. You're charged with assault or assault and battery. I need to know, do you want a lawyer to represent you?
Yes, please.
We'll set you up with a lawyer. Do you guys have that? Yeah. No, the other one.
One.
The one that I circled.
Oh, no.
Where's the file? Beth, do you have the file on that?
I looked that up. It looks like it's pending like it's not raining yet today. On a Christina Justice.
No,
That's what John told me. And
That's what I was told. And we have 10,000 things on.
wait a minute, slow down. Everybody slow down. You go out in the hall, I'll get you a lawyer.
So everything's filed there.
I need the review hearing file on Courtney. I don't know where it is. Do we have the file?
I can check and see, maybe the prosecutor has it. then they
No,
come
it's
to
up.
regular
I don't know
review.
why the prosecutor. Heather, do you have any clue where that file would
Yeah, I'm
be?
talking to Heather right now, Judge, on something.
I can look and see if it's back here, but I don't know. She doesn't qualify for a review. Oh, she's a probation review here. Too. Oh, she's
We're almost
probation
there.
review. Okay, let me look and see if she's back here.
Beth.
I'll look, John.
Okay.
Okay, thanks.
Yeah, you want me to check with the prosecutor just in case they put it as a deferred judgment? They might have given it.
Sure, that would be great. Ismail, I'm sorry, Al Hussein Ismail Al Kawali, 267841990. Okay, I got it. Go ahead,
Here's
Mr.
the prosecutor review, Your Honor, we got sidetracked on something. Heather said she doesn't think she qualifies. That between probation.
What?
Okay.
All right,
No,
Mr. Cayley, get close to that device. Tell me your name.
Good morning, Judge Roger Keeley, on behalf of the respondent in this matter.
No, a little closer. You're going to plead to impeding on behalf of the defendant, right?
Correct.
To that charge of impeding on behalf of the defendant, responsible or not responsible?
Responsible.
Okay, I'm gonna accept the plea. How's his record? All right, $180, and I'll give him until the 22nd to pay. Okay, is that good enough?
2 weeks, Judge.
29th.
Thank you.
Have a good day.
Did you say 170 or 175, Judge?
180 by the 29th.
Thank you.
Have a good day.
You too.
Cotillion.
Your Honor, at this time, we're waiting for the conservation officer, Ms. Young. She might be in touch with her. It'll be a text
All right.
message. She should get it.
Did anyone? Okay. We don't have. All right. All right, there we go. Courtney, Elaine,
Just call
Mathiasek, I can't remember the last name, how I pronounced it. 225R7243660. Good morning, counsel. Your appearance?
Good morning, William Balsky, appearing on behalf of Corey Manazik, who stays right.
Matiazik?
Oh, Ms. Hazik, I believe.
Matiazik.
Madison, I'm sorry. As fellow Polish person, it's.
like my grandpa,
yeah. So.
I said it like your grandma?
He does, but I think.
Matazik.
Matiazik. All right. Your name?
Elizabeth Westration.
All right, so you're here for a review. How's she doing?
Courtney is doing great on the program. I know this morning at status review, we briefly touched on that she had missed her probation visit with me last week. But she was within 10 or 15 minutes late. I wasn't able to meet with her due to other visits. But she did all the right things. She communicated with me. In the meantime, she completed her court work program for community service. Her VIP's been complete since February. But at this point, her probation is really revolving around treatment, her continued 12 steps and testing. She is slated to move to phase 2 next status review on April 29th, Your Honor. And I don't know much else I can add to that. She's back to work. She took the beginning of her program off from work so that she could accomplish those items. So I do have her in full compliance, Your Honor.
Just for the record, so I ordered a year jail term with credit for 1 day and said she was to serve 60 days beginning today, that I could consider not requiring her to serve it after a review hearing. What do you want to say, Mr. Volsky?
Well, first and foremost, Your Honor, most importantly, my client is 7 months sober. I know that she was given a gift here. She's taking full advantage of it. She's remains sober. She enjoys the program. She's done everything this court has required her to do. I know that as Ms. Wild had stated, she finished community service, 40 hours. She did a 6-day work program. She signed up for the Arms Weekend. That's the first week of May. She is on a payment plan. She's made, I think she paid about a third of what's been owed. Obviously, as Ms. Wild stated, she took some time off to focus on herself and get, the sobriety under control. And she has some pretty serious health issues, which required surgery. So she's progressing well in that area as well. She's 34 years old. She resides in Farmington. She's here with her mother today. Most importantly, Your Honor, no violation. She is terrified of doing that jail time, and she's terrified of relapse. So it's a great program that she enjoys, and I would just ask you to forego giving her that jail time and just allow her to continue this program.
All right, anything you want to say?
No, thank you.
All right, so listen, I mean, all statistics tell me that somebody's doing this well, it's counterproductive to put somebody in jail, and that was the concern. But I want to caution you. So I'm not going to require you to serve those 60 days now. I'm going to suspend them until the end. But I'm going to caution you. Don't let your guard down. You're looking at a whole year here, and I will give you the whole year if you don't comply. You understand? You have to get through the program. You have to stay straight. You have to keep doing this. You're just on the beginning of this. So stay with it. Okay? All right. That's what I'll do. Thank you very much. Have a good day. Keep doing what you're doing. Thank you.
Always good to see you.
You too, Mr. Bull.
Can I approach me 10 seconds?
Sure. Come on around. How you been?
I'm doing well. How you been? Always good to see you.
Everything good?
Yeah, everything's good. Sire, if I fail, you should move straight. As you behold. But everyone's doing well. It's
Good.
great to see you. Things.
Who's gonna run for judge in Garden City?
So, do you know Nick Opaleski? He's from our office. He does MIDC work. Opaleski. So I know that Judge Hamlin was hoping his son was gonna, file.
So let's talk to him.
Yeah, he filed. He's from our office.
Yeah.
So far, I mean, we have 6 days left. So
Can you imagine?
I can't-
Post the first time.
yeah, I know.
Lasano did that.
Yeah. Well,
I had to fight against.
I mean, think about what a great situation. I mean, because it's tough, you did it. I mean, but did you replace your father?
No, he was since for 8 years. So mine was a little tougher,
Oh yeah,
I better run. See you those.
yeah. But yeah, I
You know,
mean,
it's not for everybody. Getting.
I agree. I mean, it's tough.
It's fine.
Yeah.
It's not for everybody.
Is he doing well? Because I know he's out. Is he working with your brother?
No, he's working. Lieutenant.
No offense, Judge, but he's doing pretty well.
No, he's not. I said.
Always good to see you.
Thanks. All right, Eric Anthony Catilla. Are we still waiting for Dion?
Yeah.
When are they showing up?
She said she's walking, she's in training right now, but she said she left.
Where's Mr. Catilla at?
It was up to you guys. She was already on for the swear to. I don't know if you.
Did somebody call her, Heather?
I've been, Mr. Westphal, I just talked to her.
What'd she say? She's gonna get on and she can?
Correct.
It looks like they just zoomed in. I have DNR on.
Okay, good enough. Eric Anthony Catilla, 26D 72767. Oh, okay, good morning. What? Your appearance?
Good morning, Your Honor. Attorney Corey Westmoreland, Grand, Ms. Young. Sorry, Mr. Catan.
Give him your name.
My name is Eric Catan.
All right, your appearance, officer.
Good morning, Officer Young, Michigan Department of Natural Resources.
All right, so for purposes of arraignment, does he stand mute and waive formal reading?
That's correct, Your Honor.
So, sir, you're charged with CCW, a 5-year, and then you have a multitude of 90-day misdemeanors. You do have the right to probable cause conference on the felony. At the probable cause conference, your lawyer will discuss this case with the prosecutor. At the preliminary examination, if it goes that far, the people have to show that the crime was committed and that you were the one who probably committed the crime. If they prove that, you'll be bound over for further proceedings to the circuit court. You understand that?
Yes, sir.
All right. You have the right to remain silent. You do not have to say anything. If you do say something in or out of court, whether orally or in writing, it could be used against you. And you do have the right, if you choose to submit the question with law enforcement officials, again, to be represented by your lawyer at that questioning. Do you understand that?
Yes, sir.
Probable cause conference will be April 28th at 9 a.m. Preliminary exam will be May the 5th at 1 p.m. All right. I'm going to listen to what you have to say regarding bond, and we'll go from there.
Yes, Your Honor. Mr. Patan does not have any prior criminal history. He's not on probation or parole, no other pending matters at this time. I would like you to know that he is a Navy veteran. He walked in today after receiving a phone call that this warrant was out for him. And he also assured me that he would be appearing at all future court dates and understands the importance of doing so.
Okay. Officer, any objection to a personal bond?
No, Your Honor.
Can you spell out for me where you want him to go to get printed?
I don't have a preference. I don't know if Brownstown has the capabilities to fingerprint.
I'm sorry?
I don't know who's got the capabilities down in that district to fingerprint.
Heather, have we been sending any DNR cases to any specific department?
Not that I know of, Judge.
I have no preference, Your Honor. Whatever's easiest for you or him to decide.
Well, I just don't want to be sending people over. I'll tell you what I'd like you to do if you would. Would you call Woodhaven, Heather, and ask them if they have any objection to me sending this over on a DNR case and asking them to print and photograph? I don't know where else I would send them.
Okay, Judge.
If they haven't, if they don't want me to do that, then they can tell you and I'll consider something else. Okay, so here's what I'm going to do. I'm going to give you so would you call while I'm giving him his bond conditions, please? I'm going to give you a $5,000 personal bond. You cannot leave the state without the consent of the court. You cannot violate any law or ordinance. You must appear in court as directed. No contact with prosecution witnesses. You cannot possess firearms or dangerous weapons. They have to be surrendered to the DNR if you have any. Do you understand that?
Yes, Your Honor.
Also, I'm going to have you go get printed and photographed today. I'm filling out the order.
Your Honor, just to clarify, they have to be given to the DNR or can you give them to a family member where he would not have access?
You guys will take possession of those, will you not, Officer Young?
We'd have to log them into evidence. I'd be okay if he wanted to hand them over to family. I have no issue with that.
All right, that's good enough. So you can't possess them. You can turn them over to somebody else. Just make sure they're legally capable of having those firearms in their possession before you do that. And I'm going to have you go get fingerprinted and photographed. I'm going to say by 1 p.m. today. I'm going to say Woodhaven. But Heather, if Woodhaven says no problem, we'll send them somewhere else. I'll figure that out. You'll have to come back down here if Woodhaven doesn't want to do it. And I can understand. At any rate, that's what we'll do by 1 p.m. today, okay? So you go down the hall, get your court dates, which I already stated. You're going to have to go in front of Judge Hessen on April 28th, and then again, if it goes that far, on May the 5th. So you'll be down the hall on those, okay? Any questions at all for me, sir?
No, Your Honor.
All right. I wish you well. You can go down the hall, get your date, and I'm sure somebody from the DNR will show up on that date, right, Officer?
Yes, Your Honor.
All right. Have a good day. Thank you very much.
Thank
you.
Thank you, everybody. Have a good
TCF Live on a Wednesday. My name is Dan. It's good to have you all here with me. If you are new to this show, please do say hi in the chat. We're a friendly folk here. Please feel free to engage us. Let's go down to Florida. Wade Mercer.
Dani Ricardo, soy intérprete para que se pueda comunicar con el juez. ¿Usted me escucha?
Sí, te escucho. Mucho gusto.
He can hear me, Your Honor.
Thank you. Mr. Bowl, good morning. You're here because you were first appeared yesterday for the charge of driving a no valid driver's license.
Señor Ball, buenos días. Está aquí porque ayer se le acusó, tuvo la comparecencia inicial por el cargo de no tener licencia de conducir válida.
You were also advised that you have a hold from the United States Immigration Service.
También se le notificó que tiene una orden de retención de parte del Servicio de Inmigración de Estados Unidos.
I'm appointing the Public Defender's Office to represent you in the driving offense case.
Estoy asignando al abogado de oficio para que lo represente en el caso de delito de conducir.
Please listen to your attorney, Mr. McDaniel.
Por favor, escuche a su abogado, el señor McDaniel.
Your Honor, in case number 26197 CT, defendant's going to plead no contest to the charges as listed. The understanding? Go ahead.
A su señoría, en la causa 26197 CT, él se va a declarar no me opongo ante los cargos, entendiendo que
Sentenced to 3 days in the jail, credit for 3 days.
se le condenará a 3 días en la cárcel con crédito por 3 días.
$400 fine, which will be a civil judgment against his credit rating.
$400 de multa, que será un fallo civil en contra de su crédito.
Waiving his right to a jury trial and call witnesses.
Está renunciando a su derecho a un juicio con un jurado y a llamar a testigos.
Understands that any plea can be used against him in the immigration court.
Entiende que cualquier acuerdo en un caso penal se puede usar en su contra en el Tribunal de Inmigración.
Also understands that ICE has a hold on him and will pick him up within 48 hours.
También entiende que Inmigración tiene una orden de retención para él y que lo recogerá dentro de 48 horas.
Thank you. Mr. Mr. Bell, is that agreeable with the state?
It is, Your Honor.
Gracias, y señor Mitchell o señor Bell, ¿está de acuerdo el Estado? Lo está, su señoría.
Mr. Bowl, did you hear that agreement?
Señor Bold, ¿escuchó usted ese acuerdo?
Sí, escuché.
Yes, I heard.
Do you have any questions about that agreement?
¿Tiene alguna pregunta acerca del acuerdo?
No, simplemente voy a esperar los 48 horas.
No, I'll just wait the 48 hours.
Is that the plea you would like to enter on the charge here then?
¿Es este el acuerdo que desea aceptar en el cargo local?
Sí.
Yes.
Mr. Paul, I'm going to accept your plea of no contest to the charge of driving a no valid driver's license.
Señor Bull, acepto su declaración de no me opongo ante el cargo de manejar sin licencia de conducir válida.
I'm going to withhold adjudication of guilt and sentence you to 3 days in the Jackson County Jail.
Le suspendo el fallo de culpabilidad y lo condeno a 3 días en la cárcel del condado Jackson.
I'm imposing the court costs and fines of $400, and I'm giving you credit for the 3 days you've already served.
Le impongo la multa y costas estándar de $400 y le doy crédito por los 3 días que ya ha cumplido.
The $400 will be reduced to a civil judgment.
Los $400 se reducirán a un fallo civil.
So you've completed the jail sentence here, and as Mr. McDaniel said, immigration has 48 hours to pick you up.
Entonces ya completó la condena en la cárcel aquí. Como ya dijo el señor McDaniel, Inmigración tiene 48 horas para recogerlo.
Mr. Bowl, do you have any questions?
Señor Boll, ¿tiene alguna pregunta?
No, estoy bien así.
No, I'm fine like this.
All right, wish you the best, sir.
Bien, le deseo lo mejor, señor.
Gracias, igual.
Thank you, likewise.
What is the Spanish word for likewise, Mr. Ricardo?
Igualmente.
Igualmente?
It means
Igual.
the same,
Equal.
likewise. Yeah.
Igual means equal. Okay. Gracias. Appreciate it.
Yes, sir. Thank you.
Igualmente.
We have Cullen Jenkins. Mr. Jenkins, come on up. We'll get yours on the record real quick. Mr. Jenkins is coming up in 25-134 He's in the courtroom. Mr. Jenkins sentenced in that case to 11 months and 29 days in the county jail with 31 days credit. That was back on June 11th of 2025. However, the state and defense agreed that he could serve that sentence after doing 60 days in jail. He could serve the remainder of that sentence in Chrome And the order extending limits of confinement doesn't say, but typically, if the person completes Chrome, that fully satisfies the sentence. So, Mr. Jenkins, I think you finished Chrome and got your certificate and you're done, right?
Yes.
Great. Let Mr. Mitchell see that, take a look at that, look at the date on it and everything. So, Mr. Jenkins, tell me about the program. When did you get through and what were your thoughts
I
with it?
graduated last night.
Okay, congratulations.
Yes, sir. And
How long was the inpatient portion?
9 months.
And that's what you're through with?
Yes, sir.
Is there an outpatient portion in your case?
No, sir. I signed masters and it's an additional year long being there and I work for the landscape crew.
So are you still there? Even though you
Yes, sir,
graduated,
right
you're still
now.
on property, on ground?
Yes, sir.
Okay.
For now.
So, Mr. McDaniel, anything else on behalf of Mr. Jenkins? I don't know if this was your case or not. I frankly don't remember.
It was, and nothing else, Your Honor.
Mr. Mitchell?
Nothing for the state, Your Honor.
Okay, so does a state have any objection to reflecting that this sentence has been completed? Okay, so Mr. Jenkins, congratulations. We're going to show that you completing that sentence, that inpatient program has totally completed your sentence. Do y'all have a copy of that certificate of completion in the court file? We need to get a copy of that. Can you scan that here? What's the best way to get a copy of it?
Probably the best way is to.
If you'll take it on your way out, if you'll take by the probation office, keep your original. Let them make a copy, give you back your original. We'll then take that copy and we'll file it in the court file. Mr. Goodson will take care of that. Do you have any questions?
No, sir.
Wish you the best, Mr. Jenkins.
Thank you.
Yes, sir.
Thank
you.
Barbara, thank you for the $10 donation over at courtroomfiles.com, labeled coffee. Thank you very much. We'll make that happen after the show. Appreciate it.
Can you put a clerk's note in there? What happened today? That should be sufficient there. All right, we do have one person that has friends or family here, so we'll take that case next. That's Jaden Durant. And Mr. Corporal, I got his name spelled a couple different ways. The first appearance paperwork does not have a Y in it. And the jail sheet does not have a Y, but the first appearance list does have a Y. Mr. Durant, does your first name have a Y in it?
No, sir.
I should have one. We missed it, sir.
No problem. So, Mr. Durant, we just want to make sure all the paperwork matches. Mr. Durant, you're here in case 26-189MM. You were first appeared for the offense of battery. I think your mother was the alleged victim. I believe she's here this morning, and she wants to be heard on that. You were set a bond. So, ma'am, come on up if you will, so I'll make sure he can hear you. We'll be glad to listen to whatever you want to tell us. So what I'm going to do, ma'am, is get your name and place you under oath. What's your name, ma'am?
Amy Pulver.
Ms. Pulver, let me get you to raise your right hand. Do you solemnly swear or affirm the testimony you're about to give in this case to be the truth, the whole truth, and nothing but truth to help you God?
Yes.
Thank you. So, Mr. McDaniel, do you want to ask her specific questions or just want me to hear from her? Mr. McDaniel sent us an email yesterday saying that you wanted to be heard, so we're glad to listen, ma'am.
Me and my family were new to Florida, and with me being the victim of said incident, Jaden doesn't really have somewhere else that he could go other than my home. So I want him to be able to have contact with me so that he can come back home, so that he can do whatever the court systems are think that he needs to do.
Okay, couple of questions.
Yeah.
New to the areas and when?
We've been here probably for about 4 years now. He came when he was 15. He doesn't have a lot of friends. He works at the Family Dollar just across the street from our house.
Okay.
Yeah.
So he has 2 arrests since he's been here.
Yeah.
Both of them on family members, both of them battery cases. In both cases, I believe he contacted law enforcement. Law enforcement investigated and chose to arrest him.
Yeah.
In both cases.
Yeah.
The alcohol was involved in the first case, according to the complaint.
Yeah.
This current complaint doesn't mention alcohol. So my question is, was there alcohol involved in this case?
That I'm aware of? No.
No indication alcohol was
No.
involved. Are you in fear of him?
No. I don't fear my son. The reason why it was called was because I was taking the door off so he wouldn't break the door, and that he called the police.
So if alcohol wasn't involved in this case, what keeps causing these reoccurring issues where law enforcement's called?
That I don't have, sorry, I don't have medical insurance for him. He's bipolar, so he needs.
You think there's some medication that might help, but he doesn't have that?
But he doesn't have access to it, so.
Really?
as his mom, I understand when he's having a bad day. That day I went and I mowed the lawn, trying to not have a confrontation. But yeah, so
Are there other ways he can get the medication without insurance?
he's gonna have to try to get some Medicaid. I can't, with my job, it's not provided, so I would have to pay $1,100 a month just for insurance. I can't do.
Do you know the medication he needs? Has the doctor said that in the past?
When we were in Utah and when we first got here, he was on medications that were helping.
You said medications plural, more than one.
Yeah. He had an ADHD medication and then a medication for his bipolar. When you're bipolar, you start to feel better. You think you're fine. You don't have to take the medication anymore. And so I think now as he's grown, he's understanding that he's going to have to do those things. So steps towards him being able to do that, I think would be beneficial. But I don't know how.
Ms. Pulver, prior to the arrest here, had he ever been arrested or charged with a crime before?
No.
The first arrest here?
Yeah.
That was the one against this sister, which I'm assuming is
He
your
just
daughter.
barely turned 18.
And that one was dismissed after several weeks, a few weeks. Okay.
Yeah.
I'm going to see if the attorneys have any additional questions for you. Mr. Mitchell, Mr. Bell?
We spoke to her beforehand, so I think all the answers that we needed were given to us. As it pertains to the no contact, which I think is going to be your next question, Your Honor, we have no objection to amending the contact provision to no violent contact with him. We just also stress that he understand how important no violent contact means. If something like this happens again, he can be arrested and held without bond in this case. But we have no objection to no violent contact between the two parties.
Okay. Mr. McDaniel?
I don't have any questions, Your Honor. I mean, I told Mr. Durant this yesterday. He needs to quit calling police. I mean, it's not that he just called twice. He's called multiple times. And I mean, that's what's going to happen when you steadily call police for non-emergencies. That's what I've seen in the past, at least.
Mr. Durant, do you have any questions? Don't talk about your charge, but you understand what's going on? Do you have any questions about any of this or anything you want to tell me?
No, sir.
Okay. So I don't have a problem with a conditional release under these circumstances. It seems like both sides are in agreement, but it's just going to add more financial.
Got a job. He's got a job.
Okay. So the cost supervision on a conditional release is $30 a month. So it's minimal. It's probably maybe the lowest in the state. It's been the same. I haven't raised it. It's been the same since I've been here 13 years. So Mr. Durant, what I'm going to do is let you pick between the current bond you have set and also going to offer you a conditional release based upon what's happened here today. If you accept the conditional release, you would have the standard conditions of release. I don't know that anybody explained that to you. I may have before. I did explain it to you because I told you may be a conditional release candidate, but only if you had a place to live. So if you accept the conditional release, you'll have the standard conditions of release. Instead of no contact with your mother, you'll have a condition of no violent contact with your mother. You'll have a condition to take medications as directed by a physician. So that means if a physician prescribes some, that and you can get it worked out, he has to take them. But otherwise, can't make him pay for something he doesn't have the money to pay for. And so, Mr. Durant, you'll get out of jail today after you accept those terms and have no violent contact with your mother. Is that what you want to do, Mr. Durant?
Yes, sir.
Mr. Durant, has the jail already given him a notice for his court date?
Yes.
You've already got a notice for your court date. That court date will not change. It'll be the same notice you have. What's going to happen next, ma'am, is they're going to let him get dressed.
Yeah.
Then they'll bring him to the courthouse.
Okay.
Because that's where the conditional release office is at. When he gets here, he'll meet with Mr. Goodson or Mr. Ham, one of our conditional release officers.
Okay.
They'll go over the conditional release with him. They'll explain it to him. They'll give him a copy of all the rules in writing. They'll give him a chance to ask any questions he has, and then he'll be free to go.
Okay.
That's usually about a half hour, maybe 45 minutes from now.
Okay.
He'll be downstairs inside the conditional release office, which is the same as the county probation office.
Okay.
In the judge's office where you were this morning.
Yeah.
Do you have any questions?
No.
Mr. Durant, any questions?
No, sir.
We'll see you on your court date and we'll see where it goes from there, okay?
Okay, thank you.
Thank you for coming, ma'am. Sir, are you here for a first appearance case in the back? What case is that?
I think that's Mr.
Okay, for a pretrial? Okay, we're just, I just want to make sure you weren't here for a first appearance case. The next first appearance case we have is Elizabeth. Actually, we have several violation of state probation. So let me see. Elizabeth Muccio, Nathan Kroger, Charles Ford, June Brentfield, Massey, Susie. I apologize if I mispronounced any of those or some of those. Elizabeth Muccio, raise your hand, please. Okay, we got Ms. Muccio, Nathan Kroger, Mr. Kroger in the back. We got Charles Ford, big fella there, tall fella. We've got June Brentsfield, Ms. Brentsfield there on my left, and we've got, is it Massey, Susie, is that correct? Macy. Okay, I'm seeing you at the same time because your cases are identical for first appearance purposes. In all of your cases, you have a no bond, violation of state probation, or violation of supervision warrant. In each case, there's no bond. In each case, it's been signed by the circuit judge. In each case, I'm arraigning you this morning, which means I'm making you aware of what your charge is, which I just did. The second thing I'm going to do is I'm going to appoint each of you a lawyer in your violation of probation case if you're asking for one. And then after I do that, we'll see if you have any questions. Ms. Muccio, would you like to have an attorney appointed to represent you?
Yes, please.
Great. Mr. Kroger, same question?
Yes, sir.
All right. Mr. Ford, same question?
Yes, sir.
All right. Miss Brinsfield, same question?
Yes, sir.
All right. And Miss Susie, same question?
Yes, please.
All right. I'm appointing the Public Defender's Office of the 14th Circuit to represent each of you. I'll listen to Mr. McDaniel, and then I'm going to see if either of you have any questions. Mr. McDaniel?
Your Honor, we're going to plea of not guilty as listed on the May 7th arraignment pretrial docket, and I advise them all that it'll be an attorney that will come visit them prior to that hearing.
May 7th. Thank you. Mr. Mitchell or Mr. Bell, anything?
No, Your Honor.
Ms. Muccio, any questions, ma'am?
No.
All right. Have a good day, ma'am. Mr. Kroger, any questions? All right, sir. Have a good day. Mr. Ford, any questions?
No, sir.
All right, sir. Wish you the best. Ms. Brinsfield, any questions?
No, sir.
All right, ma'am. Wish you the best. And then we have Miss Susie. Miss Susie, any questions?
No, sir.
All right, ma'am. Y'all have a good day. That brings us to John Winchester. Corporal, whoever put Mr. Winchester's name in the system on the booking sheet misspelled his last name, it appears, and left off a T. So everything else has a T in it. Mr. Winchester, good morning. You're here because you've been accused of one count of petty theft of less than $750. Mr. Winchester, there is probable cause for the charge, and I'm appointing the Public Defender's Office to represent you. Please listen to Mr. McDaniel, your attorney, and we'll see where we go. Mr. McDaniel?
Your Honor, we just asked for a reason. I think Mr. Winchester is mostly concerned about some dogs he has at his campsite, and wanting to try to get out and go do something with his dogs, and so.
Thank you. Mr. Mitchell?
Your Honor, we just be asking for a reasonable bond,
Sure.
no contact with the victims.
Okay, Mr. Winchester, I did look at your criminal history. I saw that you were sentenced to jail within the last year or so. I'm going to set your bond at, you're requesting a cash bond or not?
Yeah.
Mr. Bell, any objection to a cash bond?
No objection to a cash bond.
$250 cash only is your bond. You have a condition of no contact with the alleged victim at all. The jail's going to give you a notice for your court date, Mr. Winchester, and that will be
April 27th.
April 27th at 9 a.m. will be the notice they give you. That's when you'll be in court. You've got a $250 cash bond. As soon as that bond's posted, you'll be released. You do get to use the phone at the first appearance. So you can, if you post the bond, you can take care of the animals yourself. If you can't post the bond, you can contact friends or family for whatever purpose to let them know the bond's set and give them some instructions. Mr. Winchester, do you have any questions?
No, sir.
Have a good day, sir.
Yes, sir.
I believe the next case is going to be Justin Danzy. Mr. Danzy, good morning. Mr. Danzy, you're here because you've been accused of one count of aggravated child abuse. Mr. Danzy, I read the complaint. It's a lengthy complaint. In this case, I think it's about 6 pages long. The narrative is 1, 2, 3, well, it's 4 pages. I had to look up a couple of words in there that I honestly did not know what they meant. But I have read the complaint. There is probable cause. I'm going to listen to the attorneys, Mr. Danzy, and then we'll see where we go with bond. Mr. McDaniel, anything?
Your Honor, I thought the complaint was pretty thorough, so we just asked for a reasonable bond.
Mr. Mitchell, Mr. Bell.
Yes, Your Honor, the state and we have let the defense know, we have been provided with photographs from JCSO that the court can also review if they wish. Given the nature of the photographs and the complaint, we do feel that there's substantial probable cause for the two elements of aggravated child abuse, that the defendant maliciously punished the victim and that the victim was under the age of 18. So we'd be requesting a high bond.
The complaint, as lengthy as it is, does not include photographs. Are the photographs something the state wants me to be able to see and consider for bond purposes?
Yes, Your Honor.
Okay, then Mr. McDaniel has the right to see those too.
I've seen them. It's just
Okay.
what it described in the complaint is nothing.
Let's see.
47 pictures.
While I'm looking at these, I have read the criminal history and there's multiple prior arrests, although not anything of violence like this. It's mostly driving offenses and similar stuff.
Your Honor, I'm not a violent person. I was asked to punish the child, you know what I'm saying? I mean, I love this boy. I'm sorry.
Mr. Danzy, Mr.
I'm
Danzy.
sorry,
remember-
I apologize.
Yeah, those are pretty bad. Those are really bad.
He'll comply with any order, Your Honor. I think one thing I saw was a couple driving offenses and
I think it.
and maybe something that was dismissed as a juvenile, but I mean, it was not much, nothing of violence I recall seeing.
And this allegedly was his, not even his stepchild. It was his girlfriend's child.
Yes, Your Honor.
I've been
Sure,
with her
for
6
marriage.
years. I've been with her 6 years, Your Honor.
Okay, so
I've
yeah,
been-
girlfriends.
Okay.
That's all right. I understand.
Okay. The pictures do give context to the allegations. Again, they're just allegations. I'm looking through the criminal history and a couple of Alabama thefts, but that's 10 years ago, 10 plus years ago. And then everything else, Mr. McDaniel's driving offenses. But I believe, I'm almost positive, aggravated child abuse is a first degree felony because we had that issue come up recently. So child abuse is a third degree felony. Aggravated child abuse jumps to a first degree felony. Is that right, Mr. Bell?
I believe so, yes, Your Honor.
Yeah, it does. I looked at it recently because I just learned that within the last 3 weeks. Mr. Danzy, given those photographs, and I know you don't have much of a history, the problem is the photographs are pretty horrible. So your bond set at $50,000 cash or surety. You have a condition of no contact with the alleged victim at all. Is the state requesting additional contact of no unsupervised contact with other minors? The one with the alleged victim is kind of a no-brainer.
Right.
What
No.
about other minors? I'm concerned about because the complaint
Yeah,
implies
but
maybe
other
other
kids.
children. Just a second, let me finish, Mr. Danzy.
Yes, sir.
The complaint implies there may be other children. I think there may be other children belonging to the same woman.
Mother's got 2 other kids.
Yeah, I don't know if he has children or not now, but I'm concerned about other children and her letting him discipline other children. So what's the state's position on that?
We would actually request no unsupervised contact with any other minor since they're, from the information I just gathered from Mr. McDaniel, I believe that the victim has 2 siblings.
There may be other things you want me to hear on that. He may have his own children that are outside of that relationship, but I need to know.
I'm not aware of that, Your Honor. I mean, Mr. Danzy, you don't have any kids, do you?
He's 18.
Yeah, or they're grown. I mean, we just asked, I mean, obviously this is a case that I'd not saying it's not serious, but I think odds are it's going to end up being a third degree felony case when it's all said and done. We just asked to take those things into consideration, Your Honor.
I think there's a good chance you're right.
I mean,
I think with his history, there's a good chance you're right. I think there's probable cause for first
absolutely,
degree.
I'm not.
But I think it fits enough for probable cause for malicious. But the injuries are above the knee, lower back, and some wraparound on the groin area. But there's not like there's injuries on his facial area. He didn't beat him over the shoulders. And I think those are factors the state has to figure out what they want to do with it. So you're going to have a condition, no contact with the alleged victim, and you're going to have a condition of no unsupervised contact with other minors. So you can have contact with other minors as long as supervised. You can have no contact with the alleged victim. Mr. Danzy, they're going to also give you a notice for your court date. The jail staff will. Your court date will be May 5th at 8:30, Mr. Danzy. And you will get to use the phone in a few minutes, sir, to post that bond or try to post the bond. Mr. Danzy, do you have any questions?
Is there a way I can appeal for a cheaper bond?
You certainly can ask for a bond reduction, but it's It's very difficult, almost impossible to do that without an attorney first, because the only way the bond's going to be lowered is if there's additional circumstances or facts brought to either my attention or the judge's attention in your case, which would probably be Judge Garcia. So what typically happens is if you're not able to post the bond, once you get an attorney involved, you can talk to the attorney in more detail, and the attorney can ask for a lower bond, and that judge will make that decision. Usually it'll go before a different judge because one judge has already looked at it and set a bond. So the theory is your chances may be better with a different judge that may view things slightly differently. She may not. That'd be her call. Okay?
Yes, sir.
All right. Have a good day, sir.
Thank you.
We have Willie Corbin next. Mr. Corbin, good morning. Mr. Corbin, you're being brought up today in case, is that case number right?
26167 MM.
So that should be MM, not CF. 26-167 MM. Mr. Corbin, I'm appointing the public defender's office to represent you, and Mr. McDaniel's added you on the docket to see if we can make some progress in your case. So please listen to your attorney.
Your Honor, I spoke with Mr. Corbin. He's going to plead no contest to the charge to the case number I just listed under that charge, possessing paraphernalia, 30 days in the county jail, credit for 17 days, $385 fine, adjudicated guilty. He has waived his right to a jury trial and call witnesses, and so resolve this case today.
Thank you. Mr. Mitchell or Mr. Bell, is that agreeable with the state?
It is, Your Honor.
Mr. Corbin, did you hear that agreement?
Yes, sir.
Any questions about that agreement?
No, sir.
Is that the plea you would like to enter, sir?
Yes, sir.
Mr. Corbin, I'm going to accept your plea of no contest to the charge of possession of drug paraphernalia in case 26-167 MM. The judge is guilty of that offense, sentence you to 30 days in jail, give you credit for 17 days you've already served. Order court costs and fines of $385. And those will be reduced to a civil judgment if you don't get them worked off at the jail. Hopefully you'll get them worked off through the trustee program, Mr. Corbin, and they'll be over with. Mr. Corbin, there's no probation involved in this sentence, so you finish these 13 days you have left. At most, you may do less than that under Florida game time law, but at most you have 13 days left. Mr. Corbin, any questions?
No, sir.
Have a good day, sir.
Yeah, you too.
Sir. Thank you. That's it on our first appearance docket, as far as I know. Anything else from the jail?
No, sir.
Okie dokie, friends. TCF Live. It's Wednesday. I am running a show and finalizing my taxes. Welcome to April 15th, everybody. It's the most horrible time of the year, but I get to spend it with all of you, so that makes it all right. Hope you're all having fun. I know I am. Let's go to Michigan. Judge Simpson.
May be seated.
Good morning, Your Honor. Alexander, on behalf of the people, the people who have any potential conflict between this honorable court and the Office of the Public Defender, while the people don't believe such a conflict to exist, people make this waiver in avoidance of all doubt, and I will go get Mr. Brown.
Okay, thank you.
It is a PD.
The PD case. In custody? Yes. In Jim. Okay. Oh, this is good. I don't have a prosecutor. I don't have. But Mike Benson's here. That means it's going to be a good day.
He's on his way from back.
Back where? Oh, okay. Being whom? That's going to be a minute. Welcome. Waiver.
The Office of the Public Defender does not believe that a conflict exists between this honorable court and the Office of the Public Defender, but if one were to arise, we would waive any such claim that a conflict exists.
Court for its part also does not believe there's a conflict either in the Michigan court rules or the cases decided there under that a conflict does exist given the waivers. Court will, court will consent to hear the matters. All right, I'm just gonna go. Court does call the case of the People versus Carla Brinson.
Ellis and on behalf of the people.
Ron Ronning on behalf of Carla Bristow, but not with.
It is. Ma'am, can you state your name?
Carla Bristow.
Your Honor, the phone number that we had or didn't have in public defender's data system didn't work, so I'm asking you to put her in a breakout room with our assistant so she can provide.
Is in Jackson County Jail.
Request adjournment then.
Ma'am, how long are you gonna be there?
Yeah, that's the thing. I could get out any day. I'm waiting on my quarter reduction.
Okay, so if you get the reduction, you're gonna be out right away?
Yes.
Okay, so let's do this. What's my next?
May 6th.
All right. What I'm gonna do, ma'am, is then I'm gonna adjourn your case. I know you can't guarantee it, but you'll be out likely before May.
Yeah.
You think? Okay. All right, so here's what I'm gonna do. I'm gonna adjourn your case to May 6, 2026, 9 a.m. When you get out, contact the Washington County Public Defender's Office, okay?
Is there any way that you could reduce my bond? Right now I have a bond, so I would be going to your guys' jail if I was released.
I see what you're saying. Hold on. What do you have for us? Yeah, ma'am, I have your bond in this case as set at a personal bond.
Oh, so I have a PR bond?
Yeah, you want me to change that?
No, no.
Oh, okay, all right. I just thought I'd ask. All right. So you have a personal bond. So if it happens, you should not be coming to our jail that way.
Okay.
All right. But like I said, make sure when you get out that you call the public defender's office.
Okay.
All right. Thank you. Bond will continue.
Thank you.
Thank you. Court calls the case, People versus Gary Gerlach.
Ellis and on behalf of the people.
Judge, good morning. Mark Ellis representing Gary Gerlach. Sir, please tell the judge your name.
Gary Gerlach. All right. And as to the arraignment,
Your Honor, my client would need a formal reading of the charges, would enter a plea of stand mute.
Defendant having waived formal reading, standing mute, court will enter not guilt. All right. And what are we gonna do?
Your Honor, there's no offer on the table at the moment. I would ask the court to put this in on your trial docket.
Okay, I'm not sure what that means. Do you want me to adjourn the pretrial or you want me to set it for final settlement conference and jury selection?
A final settlement conference would be fine, Your Honor.
All right. What I will do, so I'll set jury final settlement conference for
June 5th and June 8th.
June 5th, 2026, 9 a.m. Jury selection. Be June 8th, 2026 at 8:30. Both of those proceedings are in person. I'll set the defendant's bond at a personal recognizance $5,000 bond. Order standard conditions, including no assaultive behavior or possession of any weapons. Sir, at this time, you're not to possess or consume any alcohol, recreational marijuana, or any illegal drugs. Further indicate that, is there any reason you need to go? You live on Hunt Club Drive? Okay. Is there any reason you need to go to apartment 1? That's like right near you, isn't it?
It's a close neighbor, Your Honor, but he has no reason to knock on that door.
So I'm going to make it specific that you're not to go to the particular address, but That's specifically the apartment 1C. Okay, you understand that, sir? Is there a no contact that's requested?
Alexis Gideon.
In So I will order no contact with Alexis Gideon. You understand that, sir? Your Honor? All right.
Thank you. Have a good morning.
Two things. Dry. It sounds like it's
That's unlike
out there. Court calls the case, People versus Byron Blair.
Ellis, people.
Ron, appearing on behalf. Blair.
I have co-counsel, Mr. Damian Cash, I believe, on this.
Yes.
Good morning, Mayor. Please support your honor. Attorney Damian Cash, P number 85852 on behalf of Mr. Brian Blair. And I am on the case ending in 738.
All right. Mr. Blair, can you state your name, please?
Yes, I'm Byron James Blair.
All right. What are we doing?
Your Honor, I received a certificate of completion from a program in which Mr. Blair had enrolled. I forwarded to Mr. Cash. I still think we're working, trying to resolve the case based on that information.
And also I submitted a mitigation letter to APA Cook, just waiting on return negotiations on that, Your Honor.
What I'm going to do is I will grant an adjournment on this to May 6, 2026, 9 a.m. His bond will continue, but I'm going to indicate this is the last adjournment on this, gentleman.
Absolutely. Understood, Your Honor.
All right. Thank you.
Thank you, Your Honor. Mr. Blair, we get in contact with you.
Thank you.
Court does call the case, People versus Aaron Williams.
Ellis, and on behalf of the people.
Good morning, Your Honor. Michael Benson on behalf of Aaron Williams. Mr. Williams.
Aaron Williams.
Morning. What are we doing?
Need a motion date, Your Honor?
What kind of motion? What kind of motion?
Evidentiary.
Okay, what's the motion for?
To have the case dismissed.
Okay. Is it?
No probable cause.
It'd be like pulling teeth.
My oldest daughter had 4 of them pulled a couple of days ago, and she slept through the whole thing last night. We're going to challenge the probable cause for the arrest.
The probable cause for the arrest. Okay, gotcha. When can you have the motion filed?
Told 2 weeks.
In the case you to have that filed, the motion will be due by April 3rd or April 30th, 2026. Prosecutor's response will be due by May 15th, 2026. I will set the motion evidentiary hearing date for during my trial week. May 27th, 2026, 9 a.m. Will that work?
That does.
I'll explain to you. Should motion.
All right, bond will continue.
Thank you.
Thank you. Court calls the case of the People versus Ariana Banks.
Ellis, and on behalf of the people.
Good morning, Judge.
Good morning.
Sorry.
Judge. Court shall please to Assistant Public Defender on behalf of Ms. Banks, who appears to be on Zoom.
Yes.
Banks, please state your name for the record.
Ariana Banks.
Thank you, ma'am.
It looks like notes in our file indicate that Ms. Banks would like to have this matter set for trial.
Yes.
For jury trial.
Yes, Judge.
Jury final settlement conference will be June 5th, 2026, 9 a.m. Jury selection will 2026, 8:30. Both of those proceedings are in person.
Thank you, Judge.
Bond will continue. Thank you.
Thank you.
Court calls case People versus Parita Bryant.
Ellis on behalf of the people.
We're in the Judge Torsia Feaster.
Hold on a second, Amanda. Wondering. We're-
Your Honor.
All right.
Thank you.
All right, you're welcome. He just kind of took off and no, last time we lost Vincent and we didn't see him for days.
Oh, wow.
All right.
Oh, okay. Ready?
Sorry, go ahead.
Torsia Feaster, Assistant Public Defender on behalf of Miss Bryant, who I hope is present on Zoom.
Is you could unmute, state your name, please, ma'am.
Kirita Bryant.
Thank you.
Thank you, Judge. It looks like at this time we have not yet reached a resolution.
I don't think she's been over.
Okay.
Well, no, she has. It's just not on that sheet.
Okay.
Okay, yes, she's been arraigned.
Okay.
All right, go ahead.
So it looks like we are still looking into the matter and negotiating with the prosecutor. Guess we'll be asking for an adjournment, Your Honor.
In the matter, May 6, 2026, 9 a.m. Bond with its conditions will continue.
Thank you, Judge.
14A District Court, ladies and gentlemen, where bonds continually continue as contestants continually continue to ask for continuances. Texas, Judge Stevens.
Oh, boy. Same crime, must be 4 different children. Right.
Initially, Your Honor, I
That's
don't
what
have
happened.
discovery yet. I'm not sure.
Yeah, yeah. 25 CR 549, 550, 551, and 552 are all the same type of charges, state jail felonies for abandoning or endangering a child. And that's what it is. There were 4 children.
Yes, Judge, that's correct.
Who were allegedly left alone at a hotel. That's NBC. Twelve, 9, 6, and 4 years of age.
Sure.
You've got a copy of this, right, John?
He's reading it right
I'm
now.
reading it right now. Yeah. So I'm doing it now. And the state is.
I mean, the defendant admits and states it was real stupid for her to leave her children alone. No, it's accurate. It's foolish. It's irresponsible. She left the hotel around 8 a.m. to attend a basketball game for her son in Houston and left her 4 children in the hotel room that day without supervision. she said she would send money on Cash App so the children could get food. Can't help but cringe on this one. What, is there a criminal history at all here for this lady?
I don't believe so, Judge.
All right. Children younger than 15 have to have supervision. That's just the law. And here, this is, wasn't done, apparently, according to the 4 indictments here. I mean, the children ranged from 4 to 12 years of age. And all of them were under 15 and should have been supervised. Okay. This is a year old. What are we gonna do?
Ronnie, I just now got on the case. This is an initial appearance. I'm not sure why it's taking this long to get to the court. But I need to go over the discovery and review it with my clients. I'm in about 4 weeks, 3 or 4 weeks, whatever the court wants. You can make an announcement next.
Where?
Just arrested. in
Okay,
March
for that.
of this year.
Where?
She was just arrested in March of this year. So that's why.
Where is your residence?
In Louisiana.
You know, it's a big state. You're gonna
Just-
give me any more hints than that?
And
This is just terrible. Where?
Sulphur.
What, ma'am?
Sulphur.
What's your address, ma'am? Sulphur, Louisiana is a big city. Thank you. Go ahead, start over.
20 Fowler, Fowler Drive, apartment 131. Sulphur, Louisiana, 70663.
Okay, at that Fowler Drive, is there a number other than 20? Is there like an apartment number? or anything?
There's one.
All right, in each of these cases, ma'am, you are facing state jail felony in 4 of these cases, which carry with it up to 2 years in the state jail, no less than 6 months, up to 2 years in the state jail in each case. So that's a grand total of 8 years confinement in the state jail prison. So it's serious. And you're asking for 4 weeks?
4 weeks, I can go over the discovery. Fine.
What, this is over a year old. What has happened in this past year regarding the children?
They're with their days.
Okay. And is that court ordered somehow?
Well, no, the case, the CPS case is over. We completed all the stuff. They said they was trying to see where this case was gonna go because one of the things was gonna be listed is that I can't have contact with them. So they kept on with it.
All right, so the father of the children
Yeah.
has custody, essentially.
Yeah.
Do you get to see the children on,
Well, as of this case, I can't have contact.
no contact with the children? Well, that can't be happy for you. So obviously, these are serious matters, but they are fixable. Mr. Wester is a good one. And I guess you want to have a familial, a parenting mother relationship with the children, right? Well, there are ways of fixing that and dealing with this. You've not been in any felony trouble before?
No.
All right. Well, this is the room for second chances when they're earned, and it's the right thing to do. But yeah, why don't we try to figure out how we can hasten this so that if it can be moved, you know,
Yes.
one of the terms and conditions of probation would be getting her back. She's on supervision through probation. We can wean her back onto the contact with her children, which is, I think, a vital thing for a parent, if they still want to be the parent, like she said. So,
yeah.
All right, you got 4 weeks. Okay, we'll reset it, and then I'll put an asterisk on that, looking to see what the plan is, and we'll try to move it in a responsible, expedient way.
How did that one?
I have quarterly Cornish, please. Is that you?
Yes, sir.
Okay. Do you have an attorney at all?
No, Your Honor, I called the last time I was up here, you told me to call and get, just to see. what I
Okay.
did.
Is it, well, since there are 2,500 cases on my docket, your face was, people were familiar face, but I couldn't tell you what the matter was all about. A couple of things jump out at me. This is an indictment that is 1.5 years old.
Yes, sir.
And we're just in the very initial stages, and you must have moved. This shows your address was 5201 in Orange. Have you moved from there?
Yes, Your Honor.
That's why we don't know where the heck you were, and it took a lot of time to find where you are now. Where are you living now?
I live at 8351 FM 365. Beaumont, Texas 77705, trailer 85. However, I was still living in Orange County when they arrested me.
Number 35?
85.
85.
Yes, sir.
When did you move to 365 from 365?
I've been there a couple months now. I just don't remember the exact month.
Okay. But do you plan to continue to reside there for the time being?
Yes, sir.
Okay, you are charged with a state jail felony of unauthorized use of a motor vehicle, which carries with it, like the previous case, up to 2 years in the state jail. And are you working somewhere?
Yes, Your Honor.
Where's that?
I work at the Booster Buddies in Nederland, off Nederland Avenue.
The what buddies?
Booster Buddies.
That sounds like a friendly group.
It is. It's
What do they do?
It's just a thrift store.
Oh, okay. I didn't, thought maybe you help people whose batteries were dead out in the field. Booster buddies.
Yeah, I'm very limited
Boosting
to
them.
what I can do through work.
Okay. Are you able to hire a lawyer?
No, Your Honor.
Why not? Because the income?
Yes, sir. And I have 2 children and I'm a single parent.
Where's the quotes responsible father? Don't know, in the wind, took off, doesn't take care of the children? There ought to be a crime for that. 2 of them?
Yes, sir.
Okay. Well, you got to fix this because they're down to 1 parent now, practically. And you're going to have to fill out one of those indigent forms here in a minute. And then if the court reviews it and finds you to be indigent, an attorney will be appointed to help you, okay?
Yes, sir.
Just take it and just kind of fill it over there. Then our bailiffs are very nice people. They'll help you start on that. When you'll swear in front of a notary here, and then I will look at it. If I declare you indigent, we'll get somebody to try to help you immediately if I can find someone. And I do see a couple of of the lawyers who do indigent work here for us, okay?
Yes, sir.
All right. Fix this and get this taken care of. You don't have a criminal history, right?
Your Honor.
Well, you don't want one, and this is a fixable thing. And this is a very nice lady who is fair and should be handling it. Ms. Moore is going to be handling this case. Okay, so thanks, Kendall will help you. And then Dale Jones. Dale Jones. That's you?
Yes, sir.
Okay, in 21-37113, what we have here is a motion to revoke unadjudicated probation. So you have been on probation for several years.
Yes, sir.
Looks like July 28th, 2022. And you are on probation for 5 years on the state felony of abandoning or endangering a child, which this would be getting toward the end, except this shows, according to this motion, and the reason that a motion to revoke your probation was filed, it is alleged that you failed to report to the probation office on or about September 22nd, 2025 and October 9th of 2025. I guess you were supposed to report bi-weekly or every 2 weeks. Bi-monthly, every 2 weeks. And then you failed to do that. What happened on this? Was he an absconder?
No, Judge, he wasn't an absconder.
Absconder means you quit reporting and then we had to go find you somewhere. That happens from time to time. It's never a good thing, because if you can't do anything else, and there are on a probation order, there are about 34 conditions, although most of those are the conditions that all of us in this room have to follow. Number one, commit no offense. And we all have to follow that one. Don't associate with disreputable people. That's always good for everybody. Don't use or possess drugs. See, most of these are things that I have to follow. So this isn't something special. The thing that's special is you report to a guidance counselor, as it were, our probation office, which has a 13 out of 14 success rate, 93%. And if you don't report, you're not on probation. You're on your own probation, which is what gets you in trouble. How long was he not reporting? Do we know?
Judge, from my understanding, he was on courtesy supervision, being seen in person in Harris County, and he was supposed to be reporting monthly with our probation officer here. He had actually been doing good for a very long time.
It says every 2 weeks. He didn't report September 22nd and then October 9th.
It's
which is
different
2
month.
weeks,
He's
20.
once a month.
It's a month.
It's a once a month.
It's not like the third week or fourth week. That was a 2 month, that was a 2 week deal. But is it something that the probation officer works with them on?
Yeah, so this is from when he was scheduled to report here to Jefferson County for an administrative hearing with the supervisor. We scheduled him twice and he didn't show up. So that's what prompted the MTRP, because his failure to appear.
Okay, and the MTRP gets filed July 28th. No, I'm sorry. Gets filed on December 12th. So that's about 2 months after that October 9th point. So what happened since October 9th with him?
Well, since October 9th, Judge, I
Did
received.
he come back to the herd?
He's starting to come back around. He's starting to come back around now. And what we're asking is just for his probation to be continued and just use this as a.
When did we start back up on the track? When did he get back in line? What day?
when he was arrested for the MTRP in March.
Good Lord. That's a half a year. Well, that's, I don't find that appealing, but it's what's good for Dale is what's good for everybody. I mean, everybody's gonna say, I'll take my 6-month period of, I'm gonna take off for 6 months. And I want the Dale Jones rule. I want to get back when you get me, when you catch me, then we'll just pick up where we left off. What's good for one's good for everybody. The fairness is what we're talking about up here, and that doesn't seem fair. That opens up a can of worms for everybody.
So he's been reporting consistently in Harris County, but he wasn't reporting by mail to Jefferson County as requested or as outlined in his conditions of probation.
Why not?
Because I was in a predicament. I'm kind of homeless right now, so I didn't have no kind of phone to report online. I ain't have no way down here. So, in Houston, I could just, catch the bus to go to my probation officer down there. So it was easy. So, but down here, I ain't have no ad or no phone to report.
Well, we call that report by mail though, don't we? I mean, you could do that by mail, right?
So you can report by mail like.
How about that? You forgot about that option?
Yes, sir. But
don't blame your stamps. Oh, they're high.
I was gonna be.
Well, you got to communicate, or you're not on probation.
Yes, sir.
Well, you're looking at 2 years. First of all, you're looking at a conviction. This can be revoked. You can be revoked, found guilty, and then sentenced to 2 years. How much time does he have credit? How much time do you have credit? How much time have you spent in custody in this case, in the history of the case? About a long time, a short time?
I'm not quite sure how long he was in jail this last time. When we issued the MTRP warrant, we set it at a no bond. However, the county that he was arrested in set bond and he bonded out. So I don't know how long he was in jail.
County was that? Of course.
But in Jefferson.
That's why I enjoy being here in Jefferson County and the way things are done. Because we order no bond and then they quite naturally defy the order.
But in Jefferson County, Judge, he has 15 days credit.
That's not much time toward 2 years. Okay. All right. That's your plan?
Yes, sir.
Okay. If we put you back into the game, you're going to play errorless ball?
Yes, sir.
Okay. You can't just wander off from the flock. The wolf will get you. What I'm going to find is this, that are you pleading true here to allegation 1 voluntarily and because it is true? That is, you failed to report on those 2 occasions, September and October 2025, which violated condition 4 of your deferred or unadjudicated probation order. Is all of that true?
Yes, sir.
Are you pleading true to that voluntarily and because it is true?
Yes, sir.
You understand that a voluntarily and knowingly made plea of true to 1 or more violations of probation, that is enough to grant a motion to revoke probation. Your probation could be revoked. You can now be found guilty and sentenced up to 2 years in the state jail. Understand all of that?
Yes, sir.
Knowing all of that, do you insist on pleading true today to that violation?
Yes,
It's a leap of faith. Yes.
Yes.
I find you were pleading true voluntarily. You understand and appreciate the consequences of pleading true. I could revoke your probation, find you guilty, and sentence you up to 2 years. We're going to give you another try at this. Do your best. I'm going to hold this open. We'll review it. But if you can't do anything else, report regularly. That's so important. And I know I'm looking at your material here. You're more than capable of getting through the finish line and doing great. Just do it. Okay? Yes, okay. You stumbled. Pick yourself up, get back in the game and win this marathon. Okay? You can do it. I want to review it in about 6 months, see what we're doing, but he's your guidance. He's going to get you out of the woods here and follow that. You don't want to mess up on this deferred probation. You don't want a conviction. You know how long a conviction lasts? How long?
I don't know.
The rest of your life. And that closes off all kinds of doors of opportunities. And you don't need that. Fix this. You're more responsible than this. I know it. Okay. Fix it. Okay. We'll see you back in 6 months. Do well. Yes, sir. Okay. Get it reset.
Welcome once again to TCF Live, everybody. It is Wednesday. We're about, halfway through the show now already. Time flies when you're having fun. Or as my father oddly used to say, time is fun when you're having flies. Either way, I suppose. Let's go back up to Michigan and Judge Aquilina.
You taken any medication yesterday or today?
No.
Any sign of fever, COVID, or other illness?
No, Your Honor.
Have you had enough time to speak with your attorney?
Yes, Your Honor.
And I understand there's going to be a plea today, is that correct?
Yes, Your Honor.
And I know there's been a lot going on in your file. This is a 23 file. So you've been in, I think, almost when you were in custody in another county, is that right?
Yes, Your Honor.
Are you still with that other county?
I'm on probation in Clinton County, but I'm currently incarcerated in Ingham County.
Or this?
On this case, Your Honor.
Okay, and then are you still homeless or have you?
No, actually, my boyfriend has been able to get us a house and vehicle and got my job back for me.
Okay, good. So,
Give it to you. Go ahead, give it to you.
all right. So you have 3 forms. So that's the brandy wine?
Yes, Your Honor.
All right. And I know you were previously working. Can you go back to that job or?
Yes, Ballard's cleaning. So as soon as I get out, I can start work the same day. So.
Okay, good. And you're a US citizen?
Yes, Your Honor.
At the time of this offense, were you on probation, parole, or bond conditions before another judge?
Not at the time that I got discharged, no, Your Honor.
And what is the plea agreement on behalf of the people?
Yes, Your Honor, the defendant will be pleading to an added count 2 of firearm, improper possession of a firearm in or upon a motor vehicle. That is a 90-day misdemeanor. Upon successful plea and sentencing, count 1 will be dismissed. There is an agreement to no upfront jail at the time of sentencing and forfeiture of all contraband.
Maybe go to sentencing today?
The people leave it in the court discretion, Your Honor.
No, the factor is we asked for some. I think it's.
What?
We would ask to go to meeting sense there.
Thank you. And is that full, fair, accurate, and complete in regard to the plea agreement?
It is, Your Honor.
Ma'am? Counsel, you waive your reading count 1?
Yes, Your Honor.
All right. And ma'am, you do understand that all seized contraband will be forfeited?
Yes, Your Honor.
And the weapon that you had, was it yours or someone else's who
Someone
lawfully
else's.
had it? I'm sorry?
Someone else's, Your Honor.
Did they lawfully have it?
I'm sorry.
Did they lawfully have it?
Yes, they did.
Okay, so they would be able to, it's going to be forfeited today, but they would be able to obtain it if they have the lawful licensing, et cetera.
Okay.
Okay. As to the reading of count 2.
Yes, Your Honor. People of the state of Michigan versus Nikita Nicole Taylor. State of Michigan, County of Ingham, in the name of the people of the state of Michigan, the prosecuting attorney for this county appears before the court and informs the court that on March 19, 2023, at 300 Green Park Drive, Apartment C, City of Mason, Ingham County, the defendant in an added count 2, weapons, firearms, improper possession of a firearm in or upon a motor vehicle, did possess in or upon a motor vehicle or other self-propelled vehicle designed for land travel an unloaded firearm which was not a pistol, to wit, a firearm that was not inaccessible from the interior of the vehicle. This is a misdemeanor that is punishable up to a maximum of 90 days and or $100 with mandatory forfeiture of weapon or device. And against the peace and dignity of the people of the state of Michigan.
Thank you, ma'am. Did you understand what was just read?
Yes, Your Honor.
So you understand the improper transport of the firearm in or upon a motor vehicle is a 90-day misdemeanor?
Yes, Your Honor.
And we just discussed the forfeiture, you're in agreement with all of that.
Yes.
And it looks like you signed the advice of rights form. Did you read it before you signed it?
Yes.
Did you understand what you read?
Yes.
And did you understand that by pleading, you're giving up your automatic right of appeal? If you choose to appeal, then you first have to ask permission of the Court of Appeals.
Yes, Your Honor, I understand.
You're also giving up the presumption of innocence, the ability to cross-examine witnesses and evidence, the ability to choose to provide a defense, etc.
Yes.
Seems like you're having trouble hearing me. Do you need some help? We do have some.
I mean, I'm hearing better than I had the last time, so
Okay.
it's just, when you talk a little bit closer, I hear you.
Okay, I'm gonna do this. Is that better? Okay, because we do have headphones. This can get a little loud for everyone else, but that's fine. All right, now, as to count 2, weapons, firearm, improper possession or transport in or upon a motor vehicle, how do you plead?
I plead guilty, Your Honor.
And have you pled of your own free will?
Yes, Your Honor.
And you did that after consulting with your attorney?
Yes, Your Honor.
And you've been satisfied with the representation of counsel?
Yes, Your Honor.
Ma'am, did this offense occur on or about March 19th, 2023?
Yes.
In the city of Mason County, Bingham State of Michigan? At a specific location known as 300 Green Park Drive, Apartment C?
Yes, Your Honor.
You came in contact with law enforcement?
Kind of.
How does kind of, either did or didn't?
I didn't personally come in contact with law enforcement. Somebody turned the weapon into law enforcement, and then I was contacted a couple months later in regards to it. So yes, I mean, I did, but months later.
Okay, so they contacted you because somebody provided the weapon from the vehicle?
Yes.
How did they find the vehicle?
They went through my purse.
Who's they?
They went through my purse and took it to the police department.
Do you know who they was?
Yes, her name was Capri Brown.
Did she have?
What's Brown? Capri Brown.
Can you spell it?
CAPRI.
And so, did she have lawful access to the vehicle?
No.
Your Honor, can we approach?
Yes. So, was it your vehicle?
No, it was my purse.
I see. Okay. And so the weapon was found. Is that right?
Right.
And turned over to law enforcement?
Yes, sir.
Okay. And it was not your weapon?
Correct.
You didn't have any lawful reason to have it in your possession?
Correct.
And it was found in the vehicle that you, were a passenger or driving?
It was a passenger, but it was actually found in my purse after I got out of the vehicle. It was found in the house.
Okay, but you had that purse in the vehicle as it was driving?
Yes.
Okay. And you understood that that weapon, the pistol was a dangerous weapon?
Yes, sir.
And should not have been in your possession?
Correct. Yes,
Or in a vehicle that was moving?
yes, Your Honor.
And then when police approached you, you admitted to it?
I pled no contest until it was found over, until today is the first day that I pled guilty.
Okay, and you're pleading guilty because you're guilty of violating the law?
Yes, Your Honor.
Okay. On behalf of the people, any additional questions?
The people are satisfied with the factual basis, Your Honor.
And counsel, if there's any defect in this procedure, how it was found, how this all came together, that's being waived?
Yes, Your Honor.
Any additional questions?
Just a couple. I think we covered everything, but I just want to make sure. Ms. Taylor, turn your attention back. This occurred on March 19th, 2023. Is that correct?
Yes, sir.
And-
Yes, sir.
And you were going to Miss Brown's house in Mason, is that correct?
No, I was going to my ex-husband's house, her brother, Rory Vaughn's house in Mason.
Okay, I got you. But Miss
This
Brown was,
week,
but Miss
yeah.
Brown was gonna be there, is that correct?
Yes.
Okay. And you knew you had the gun in the purse, is that correct?
Yes.
That was, even though it wasn't your gun, you had permission to have the gun in your purse, is that correct?
Yes.
And you didn't have a carry concealed permit, is that correct?
Correct.
And after, you weren't the driver, is that correct?
No.
And then when you got into the house, that's when they found the gun in your purse, is that correct?
Correct.
No additional questions, right?
Has anyone told you what I will do at sentencing?
Yeah.
Our counsel aware of promises, threats, or inducements other than those already placed on the record?
No, Your Honor.
No, Your Honor.
Does the court comply with the courtroom?
You have, Your Honor.
Yes, Your Honor.
I find defendant's plea has been freely, voluntarily, knowingly, and understandingly made without undue influence, threats, coercion, or promises of leniency. I also find there are sufficient grounds to accept defendant's plea. Therefore, count 2 will enter. Count 1 is hereby dismissed in its entirety. All weapons in contraband are hereby forfeited as to this defendant. However, if there is a lawful owner of the weapon and they can satisfy law enforcement, they may seek it back. It's been a long time, so I don't know what law enforcement's done with it. They probably still have it, but I don't know. All right. We're going to immediate sentencing
That's correct, Your Honor.
on behalf of the people.
Your Honor, I would just ask that you follow the recommendation of no upfront jail. Thank you.
Counsel?
Yes, Your Honor. Miss Taylor's been in jail on this file, I think about 35 days, Your Honor. We were here maybe a month or so ago where I guess she had absconded from a pretrial. The court had remanded her in. On this case, she had another matter pending in the district court that got dismissed. She is presently on probation in Clinton County as well, Your Honor. I think all of this stemmed from her addiction to substance abuse. My understanding is she's working towards getting those issues cleared up in 3 years. She does have stable housing. Her boyfriend Stephen's here in the courtroom, as is her father. She is on the right road to recovery and is in a different place than where she was 3 years ago. I'd ask that she give them the credit for the 35 days, Your Honor. Thank you.
Ma'am, what have you learned from all this? You're in not just this county, but other counties, and you've been in just a horrible situation. What have you learned?
I learned to follow the law. I learned to show up to court and to contact pretrial services for sure. I learned that drugs are not the path that I want in my life, and that it has ruined my life for the last couple of years of my life. And I learned that I just want to get my life together and to start fresh. And I want to make my children happy, but I also want to make my father happy. And I just want a fresh start. So, and I don't want to go to jail ever again.
Well, first and foremost, you have to make yourself happy.
Yeah.
You can't do it for someone else. It doesn't work that way.
Yeah.
You have to choose yourself. And you also need to, by choosing yourself, have the courage to ask for help, because that is a sign of strength. It seems to me from this file that is growing that you needed some help along the way and turned to drugs instead of asking for help. So I hope you've learned that lesson.
Thank you.
How long are you on probation in Clinton County?
I have the option to get off in 9 months, but they gave me 18 months probation, I believe.
Right.
So, and I have drops and I have 3 NA classes a week. So I actually in jail met some good people from there. So I think it'll be good for me to have that structure.
Ma'am, I don't think there's any need to keep you on adult probation. I could marry up my probation with theirs, but I know Clinton does an excellent job, and Therefore, I'm gonna give you 35 days of credit for 35 days. You have to pay a $50 state cost and a $75 crime victims. So that's $125. I know you've been incarcerated for a while, so I'm going to give you until July 4th of 2027 to pay that.
Okay, okay, 125.
So that should be enough time for you to put a few dollars away. You don't have to pay it all at once. You can just pay a few dollars, but we need to get $125 to close this matter totally. Otherwise, they'll just take it from tax returns or other things. And they add late fees and they do a lot of things. So that's why I'm giving you some time to pay. But part of your recovery is to make amends in every way, and that includes repaying the county. So that's $125, which is minimal compared to what I can do. And waiving fines, cost attorney fees. You have 42 days to appeal to request appellate counsel.
Thank you very much, Your Honor.
Judge,
Good luck to you.
just for the record, you said you did get a copy of the form, is that correct?
Now, do you receive? Say yes?
Yes.
Thank you. Good luck.
Thank you, Mr.
You Theodora next.
Alrighty, well, she racks up another contestant. Let's move along. We'll go back and see what's up now with Judge McNally.
They're gonna plead this to a civil infraction, which I hate to see people get criminal convictions on these, but well, you gotta make sure this child is in school.
She has, like I was explaining, she has mental health issues. I already called a counselor. She goes back on April 30th for intake. And she's just honest. I know it's not excuse. She's going through a lot. She's 12. My son, he goes to school every day. And I mean, he doesn't have an issue with going. It's just her. And I don't have my license right now. I honestly just paid $5,000, about $5,000. I'm trying to get it back. I see the people April 30th. They're gonna say yes or no if I can get it back.
$5,000 for what?
Yeah, because I had fines at Ronaldsport and I just started working full time 2 years. This will be my second year at my job. I completely turned my life around. I know probably in my file can see everything in the past. I just graduated high school. I'm trying everything I can to give them a better life. And since I don't have my license, if they're late to school, I heard that they're still marked absent for that day as well. And my mom takes me everywhere.
Are you talking to a lawyer about getting your license back?
Yeah, I go in front of, it's not a court, it's like a panel, it's OHA.
Right.
I went through Secretary of State.
I understand. So you've got a lawyer representing?
No, I can't, I honestly can't afford it. I work full time, but I don't make that much, which is why I'm getting my license. I work at Donover Estates, like dementia and Alzheimer residents.
Okay.
And I only make like 15 an hour. So once I get my license, I spoke with the lady from my church, she's gonna get me a better job. One that I can actually drive to. My mom can't take me back and forth to like Detroit or Dearborn, it's too far to drive.
Okay,
So
fair enough. So you're gonna plead to public nuisance.
she will be, she understands how serious this is now. Like we had a conversation, she knows everything I'm doing today, and she even started crying. She's like, I'm sorry, Mom.
How old is she?
She's 12. She'll be 13 in July. But, she understands.
Is the father in her life?
Yes, and he was another part of the issue, because they go with them Friday, Saturday, Sunday night, and he takes them to the bus Monday. And a lot of times, I didn't even know she was in school because he takes them to the bus Monday when he brings them back, until I got a phone call from school that she was absent. And I'm like, what is going on? So, and
Okay, just relax.
Yeah.
So you're gonna plead responsible. There's agreed upon fines that cost $200. It says you need time to pay. How much time do you need?
about 2 months. I get paid every 2 weeks,
Do you
and
want to pay bi-weekly or do you want to just have me set it up for June 15th?
June 15th.
If you need more time, you can come and talk to me. I'll be glad to give you an extension, okay?
Okay.
All right? I think you're doing the right things here, it sounds like. Get her into school. I know.
Yes.
Yeah. So what grade is she in? Sixth?
Sixth. She goes to Woodhaven Upper Elementary, it's the old Patrick County.
Is she doing all right in school when she goes?
When she goes, but because she's missed days, she's falling behind, I just got,
If you ever think, I'm serious, this case is over. You ever think you'd want to bring her in here and have me talk to her, I will do that.
I even asked the school, I'm like, you could please tell her, like, I'll go to jail, like something, and.
I'm not gonna lie to her, but I'm gonna encourage her to go to school and maybe I can talk some, you know,
That would honestly be great.
you let me know. You call Heather, give her your number and you can set her up if she calls back, okay?
Okay, Judge.
She'll give you her number down the hall. I'll be glad to do that. Good luck. Good luck. Thank you. Yeah, yeah.
Well, even said they can use their live scan, but somebody from the DWLS will have to show up with them.
Okay, Ariel, Scott, is she still on?
Yes,
Yeah. So Woodhaven will let you do that, but you're gonna have to accompany the defendant over there. You're gonna have to meet him over at Woodhaven.
Is it gonna have to be me personally, or can I send one of my partners?
You can send one of your partners.
All right.
So I just like you to coordinate with the defendant. Is the defendant still down there, Heather, I hope?
He is at the window right now, Judge.
Good. What time you want me to tell him to have him go over there?
I've got to actually figure out who else is working currently. So I'm gonna need a minute to figure that out.
Okay, Heather, tell him to wait and you confer with Officer Young by live chat or whatever. And you can tell the defendant when to go over there, okay?
I appreciate it. Thank you.
So find out, get and talk to Heather then, but don't leave, okay? Thank you. People against Al Hussein Ismail Al Khawli. 26W 841990. I thought I already called this one. I did already call this one. Why is this back up here? Is Mr. Cayley out there? What is going on?
No, Judge, we already did that one.
Thought so, and I don't. Yeah. Okay. So this is for Christina Justice for an attorney. Wild Mohammed Alanzi, 25W8388113A and B. Good morning, counsel.
Good morning, Your Honor. May it please this honorable court, Joseph Bravo, on behalf of Wild Alanzi, approaching the podium, standing just to my right. Mr. Alanzi, please state your name for the record. Anytime set for pretrial, Your Honor. We're gonna waive jury trial. Hopefully it leaves some pressure on the court. And we would like a little bit of extra time to resolve this matter. And the reason
I'm gonna do the bench trial on May the 8th.
Sorry?
If we're gonna, you got a jury trial waiver here.
That's fine. We'll set it for bench and by that time we'll have everything resolved, Your Honor.
I know, but he's gotta get moving here.
Well, it's not him, it's the courts. I mean, I'll be honest with you, I'm retained on all these matters. I'm responsible.
Isn't that the courts?
But
Why is it the,
it surely is the courts. I'm at mercy of your schedule.
whose?
The court schedule.
Not us.
No, not this court schedule.
No, we're the best. Why? Well, what do you mean?
Well,
You're at the mercy of the other courts.
Our plea agreement here hinges upon the other courts resolving their matters. I can't get the prosecutor moving in the direction that I want without these other matters being closed. And one of them is
He's
the matter's still open when it's not.
Okay, listen, I'll take the waiver.
Thank you.
We'll set it for a bench on May the 8th. I might set it earlier by a couple of days.
I don't even think I can do maybe, Your Honor.
Well, listen, I'm not adjourning this again. I'm telling you, I'm not adjourning this. I'm just not doing it. You know, look, let me let you in on a secret, counsel. My constituents are my number one boss. Number two is the Supreme Court. And they tell me I'm supposed to have 98% of these cases done within 91 days. They didn't write me and ask my opinion whether or not that was enough time. And I'm just telling you, this case is over in 91 days when I go to May 8th. Wow. I'm not adjourning it again. I will not adjourn this again. I told you that before. I wrote in big letters, no more adjournments. That was on April 1.
So I wasn't here April 1, Your Honor. I had somebody standing by.
I don't care.
At my place.
Yeah, sorry, I'm not trying to give you a hard time. I'm not adjourning this case.
Okay.
So if you want to, I can set it for a bench trial on the Woodhaven docket preceding that. Or I'll keep it on for May the 8th. And we can
May
have,
the 8th is the furthest we can go. We'll take
it's the
that.
furthest we can go.
No, that's.
All right.
Hands are tied.
All right, so sir, you understand you have the constitutional right to a jury trial.
Yes,
You understand 6 people would be impaneled right over there, and all 6 would have to find you guilty beyond a reasonable doubt in order for you to be convicted. By waiving your right to a jury trial, I will be the one who will solely decide your guilt or innocence. Do you understand?
Yes, sir.
You still wish to waive your right to a trial by jury?
Yes, sir.
Anybody force you to do that? I love those looks you're giving me. What? Is that what you want to do, is waive your right to a jury trial?
Yes, Your Honor. It doesn't seem like it's too harsh of like they don't have big charges there.
What's the question you're asking?
I don't know what you're asking. These are not big charges?
Yeah, just
Your lawyer will talk to you about all that if you want to
You
talk to
already
him.
know what the allegations are. Do you want to have a jury trial or not? That's kind of, this is where we're going with it. You already know what the game plan is. You want to keep it?
jury trial.
You want to waive or you want to keep the jury trial? All right.
All right, so you wish to give up your right to a trial by jury?
Sure.
Anybody force you to do that? And that is your signature here on this document, entitled waiver of trial by jury and election be tried without jury, correct? All right, I'll accept the waiver. Now, so I don't want to bring in the prosecutor on May the 8th, to tell you the truth. When does Woodhaven have a docket that week?
I'm sorry, which week was that, Judge?
It's the week of May the 4th.
We have, that would be Judge Hessen's Woodhaven docket on that week.
I'm setting this for, calling Mr. Urich.
Sir.
What's he get? Let me talk to the prosecutor when he comes in. Good morning, Mr. Urich. How are you?
We are well. How was the court today?
Not bad. Your appearance?
William Urick on behalf of the city of Woodhaven.
So we got this. He's waiving his right to a trial by jury. I told you guys last time I wouldn't adjourn it again. I'm sorry. I'll keep my voice up. If you want, if you can get here at 8:30 in the morning on Judge Hessen's docket, which is May the 6th, right, Heather? She's working on something else. I think she said May the 6th. Then we can take care of it that day, and you don't have to come in on Friday. Is that good? Is that good with you, counsel?
6,
Yeah.
30 a.m.
Yeah.
Make sure I don't have any conflicts. Okay. If that's our only option, then I'm gonna have to make it work for it.
Tell you. I'm here, am I here May 13th, Heather? Yes.
Yes, you are, Judge.
Let's just make it on May the 13th.
I really appreciate that, Your Honor.
Okay? And can you do it at 8:30 in the morning that day?
Sure can, Your Honor.
So we'll set a bench trial on May the 8th. I'm sorry, May the 13th, my apologies. May the 13th at 8:30. What are you looking for him to do before you reduce this? I don't know anything about this.
He has yet to obtain clearances that are showing on his driving record in the 19th and the 36th.
Just
So
clearances?
counsel informs me he's done some due diligence, but they're still there as of April 9th. So I can only go by what,
What's he gotta do?
state informed.
They're just tickets that he has to pay or pay the,
There's the fines, you know.
where does your client work?
He owns a smoke shop in Ohio.
Okay. How much does he owe in tickets? Do you have any idea?
That I could not tell the court.
Probably less than a couple $100, but he says he's paid them off. I know that he's paid them off. I'm not sure why it's not reflected yet.
Well, he might have paid him off, but not paid the clearance. That might be the easy resolution. You know, sometimes, I don't know their policies that if somebody's paid a ticket and they don't tell them, the clerk doesn't tell them, hey, by the way, you owe a clearance fee and the suspension's gonna stay on your record. That could be the answer to it. If he thinks he's paid them off, maybe he just did, but didn't pay his clearances. $45 per ticket. So anyway, you guys figure it out. I'll see you back here May 13th. No adjournments, guys, okay? Thank you. Thank you. Thank you. Martin, Mary Nicole Martin. Which one's yours again? Yeah, let me call that one first. Come on up here. El Riashi. Wasam Sala Quiet El Riashi, 268840752.
Good morning, Jeff. Not to get here and have them, so we're asking.
All right. Your name again? How you doing again? You're still under oath.
Yes.
Ask him his name for me.
What's the name that he has? What's the name of it?
I'm gonna go ahead and sign the discovery order. Does he stand mute, waive formal reading?
Yes.
I'm entering a not guilty plea. I want everybody to understand. Make sure you tell them this. I don't know what, I don't want to know. But there could be immigration consequences if he pleads guilty to this charge. I want him to understand that. So, do you understand that?
I've advised him of that, Judge.
Good or no?
I also do immigration myself, so I have advised him of its consequences.
All right, good enough. So I'll give you a pretrial date. You're going to have to fill out a petition for a court-appointed lawyer if you want one going forward. And I'm going to send you over to Woodhaven to get fingerprinted on this by 1 p.m. today, okay? By 1 p.m. today. So I will go ahead and sign the order for prints. I'm gonna give you, where has he been, by the way?
I'm sorry, David?
Where's he been? Why didn't he show up on this?
He had a hearing on the 18th of March, I believe, Judge. He said that he came in and he said he spoke to you. And then he was given today's date to come back.
No. He did, listen, tell him this. I want you to tell him what I'm telling you. Defendant failed to appear on February 18 of 26. He then appeared on March the 4th, but the clerk wrote, but confusion because of language barrier. I told the staff to get an Arabic interpreter and to reschedule the arraignment and pretrial. On March 18th, the interpreter appeared. It was not a Aman, but you didn't appear. Why?
Oh, I didn't focus, I didn't focus.
Didn't focus. Didn't focus on what?
Because of the show. Notice I didn't go.
Keep your voice up for me.
I didn't notice that I had a court date.
Okay. I understand there's a language barrier. I'm gonna give you a $1,000 personal bond. You cannot leave the state without the consent of the court. You cannot violate any law or ordinance. You must appear in court as directed. I will give you that court date in a minute. I'm also going to order that you not have any contact with prosecution witnesses and that you not enter 23555 Allen Road in Woodhaven or any other Target store. Those are your bond conditions. So you have to go over to Woodhaven and get printed and photographed. You can't go back to that Target store or any others. You cannot leave the state without the consent of the court or violate a law. You must appear in court as directed. Don't miss again. I'm signing the discovery order. If you want a lawyer going forward, you're going to have to fill out a petition for a court-appointed lawyer. I want to move this on. This has been sitting around here for a while with all these misdates and confusion. So I will give you a pretrial date. We doing the 29th, Heather?
Yes, Judge, we can do the 29th at 9:00.
All right, so we're gonna do April the 29th at 9:00. April 29th at 9:00. We're gonna give you a notice down the hall. 2 weeks from today. 14 days from today. And you give them take the notice, make sure you show up by 9:00 on April 29th. If you don't, we're gonna have a problem. Okay, and we're gonna give you the order for prints. We're gonna send it over to Woodhaven. You have to go over there by 1:00. No reason to not just go now. Okay? So you fill out a petition for court appointed. I always forget that you speak some Arabic.
Yes.
Thank you.
No.
Thanks. Okay. Good luck. Mary Nicole Martin, 267840484. Come on up to the podium, ma'am, and tell me your name. What's wrong? You all right?
Hi.
You all right?
Yeah,
Your name?
Mary Martin.
You sound like you're not excited to be here.
No. No, this is now the second time. I've been having issues with my son for over a year now.
All right, let me just arraign you. Don't say anything yet. I don't want you to incriminate yourself. You're charged with violation of parental responsibility. If you want to have a lawyer represent you, I will give you. If you like a lawyer. I'll arraign you and I'll send you to the prosecutor. It is alleged that on March 31 of 26 at 24825 Hall Road, near Van Horn and Woodhaven, that you failed to ensure the attendance of Mackay Martin. That is a misdemeanor punishable by up to 500 fines, 90 days jail, costs for all of those penalties. Do you understand that?
Yeah.
Sign the advice of rights and read and understand the rights.
Yes.
If you plead guilty, you'll be giving up all those rights and we're not going to have a trial of any kind. Do you understand that?
Yes.
You still wish to waive your right to a lawyer?
Yes.
I'll enter a not guilty plea. I'm going to send you to the prosecutor. Defendant's child to attend school with no unexcused absences. I'm going to send you to the prosecutor. You can talk to him, see if you guys can work it out. If you can't, we'll give you another court date. Any questions?
I was listening to you speak with the other lady about having her child come in.
Yeah, well, there's that case is over though. This is not a conviction yet, so I can't, okay? There's no conviction, so I can't really put the cart before the horse here, okay?
Okay.
So you go out in the hallway and we'll set you up with the prosecutor, okay?
Thank you.
Good luck. Hoff, Dustin Lee Hoff, 26741057. How many times are we gonna, what are we doing on this one? I'm not adjourning this again, am I?
Sorry.
Your name?
Dustin, how?
Same thing. Did you talk to the prosecutor today?
Not yet.
Why are you in front of me? You're supposed to go talk with the prosecutor.
Yeah, let me talk to them. I'll be sorry.
Okay. You're all right. You're all right. Go out in the hallway. We'll set you up.
Can I say I love you on TikTok?
Oh, geez, come on. Take two.
You're actually here for a ring pre-trial, pro permit.
Yeah, but he's already been arraigned on this on February 18th.
Oh, I didn't know that the docket didn't reflect that.
Yeah, that's all right.
I just go by what the docket says.
Counsel, what in the world do you have here? Mr. Ikeban, what do you have?
Good morning, Your Honor. Please forgive me. I have Manian Express. We were able to strike a plea, Your Honor.
Okay, when I get the file, I'll be glad to take it. I just don't have the file yet. Do we have that, something express?
That would maybe with the prosecutor, Judge.
Yeah, I see. Is who's the lawyer for Salamat Nasser El Jalam? Anybody?
Let me take a
Who's the
look.
lawyer for Salamat El Jalam, or his defendant just failed to appear for sentencing?
That was Mr. Crawford was on that one, so it looks like he may just failed to appear.
Well, I'll wait till Mr. Crawford comes in on that. All right, can you grab that one file for me, please? And I'll get the lawyer out of here. Brianna Marie Eccles, 6W842050A. Did I give you a lawyer, ma'am?
Yeah, Crawford is the public.
Okay, well, I'll have to wait for him then. I'm sorry. How you doing, John?
One of those days, Judge, I don't know, some rain or something, I don't know what's going on. Seems like just one little bit.
All right, as Judge McNally's courtroom experience is one of those days, it is emptying out for him, though. They'll bring in another batch soon, I'm sure. But let's change it up. Let's go down to Louisiana and check in on the board.
And I'm just going to turn it over to Mrs. Ledoux because Mr. Neal's case has been assigned to her. And I think I see we have someone here of sheet on who that is. Say about we want to acknowledge our observers.
I will say that Jeffrey Neal is the inmate we're referring to. His DOC number is 118676. Mr. Neal is serving a life sentence for sexual battery and kidnapping. He has served apparently around 38 years. Staff there can correct me if I'm wrong. We have a number of family members in support of Mr. Neal's release on medical parole. And we have 3 who would like to speak. The ones not speaking are Darlene Neal, sister, Carletta Young, cousin, Marvis Neal, brother, and Wilbert Jefferson, cousin. We'll go ahead and let Fred Neal speak now. Mr. Fred Neal can address the panel. I'm sorry, I don't know which.
Yes, can you hear me now?
Yes, thank you.
Good morning, everyone.
Morning.
I just wanted to speak on behalf of my nephew and Angela Jeffrey Neal. I've been going to see him over the last 20-some plus years up in Angola. And I was just with him on last Friday in Angola. But I just want to say I've gone on routine time, and I've seen the progress in him over those years in Angola. First, when he became a minister after completing the coursework there with the New Orleans Ministry Theological Society, theology, there in New Orleans, anyhow. But I would visit with them and saw him with the ministry group that he had there in Angola before he got hurt, the club that he had. And I've also been there on a number of occasions for banquets with the group. And like I said, I've just seen him minister and visit with him in the chapel and different services also. And also just went over to visit with him, the respect that the other inmates, not only in his club, but the others had with him as he ministered in the cell blocks over the years. And so it's been actually it's just a little over a year ago when he had the stroke at Angola. And it was touch and go there a while when he was here in Baton Rouge at our late. But God was able to bring him through that situation. And like I say, he's come a long way in the last year with the stroke that he had. But I just like to say, even before that, he's a changed individual. And I think he did a lot of good with the inmates there in Angola, preaching the word of God and just being a blessing to them and also a blessing to the family. And so I think he deserves to be out of Angola now, and his family would definitely take care of him or try to take care of him once if he's a rogue.
That helps us to understand. We can go on now to Curtis Banks, the cousin.
Let's see, can I get unmuted? Can you hear me now?
Yes.
Okay, well, good morning, panel. Good morning, everyone. I'm Curtis Banks. I am a cousin through the marriage of Sheila, who is the first cousin of Jeffrey. I'm the senior pastor of First Church of God in Christ here in Huntsville, Alabama. And also, I'm a retired master scientist for the last 30 years. But I have known Jeffrey since around 1985 when I visited my wife's family there in Bastrop. Since Jeffrey in incarceration, my wife and I had visited him many times over the years. We only slacked off during the pandemic. However, Jeffrey, in my mind, what I have seen in him is a man of God. What I have seen in him, he spent most of his time in prison transforming the lives of young men with the gospel of Jesus Christ. And I believe only a transformed life can affect the lives of others to walk in the image of Christ. What I believe is that at the age of 67 and him being limited physically, I believe that Reverend Neal will not turn his back on his Savior. I believe that he's committed to the Lord, and I believe he's committed to the gospel. I believe that allowing him to go home is the best thing that can be done for him at this time in the stage of his life. So I like Cousin Fred, I do believe that the best thing to do is to allow him to leave from Angola. Thank you, and may God bless you.
Thank you so much, Mr. And now we also have Marvis Neal. I believe that's your brother.
Yes, can you hear me?
Yes.
Yes, I'm Marvis Neal, Jeffrey's younger brother. Jeffrey Neal has always been a very important part of my life. He has been incarcerated a number of years, and like my uncle and my cousin spoke before him, He has turned his life over to Christ, given his life to God, and like my uncle said, ministered to several inmates in Angola. And every time I'm able to speak with my brother, every conversation centers around how he's changed his life. He doesn't have a woe as me attitude. He always speaks positively. Um, when I had the time to visit him at my mother's funeral, very touching for me and the rest of the family. And like my Uncle Fred said, if through release on parole, he has a great support system, his family, 3 brothers, sisters, many aunts, cousins, and everything that'll be there for him. So, on his behalf, and my family behalf, we ask that you do grant him medical parole. We are blessed to have not lost him during his medical injury. So we just think that is the best course of action for him. And I thank you and the parole board for allowing me to speak. Thank you.
Thank you very much. We appreciate that. At this time, we would ask Jeremy to give us a synopsis of the medical condition that Mr. Neal finds himself in at this time.
Yes, ma'am. Mr. Neal, he's 67. He's got a history of hypertension, hyperlipidemia, prediabetes, and then in April of 2025, suffered a pretty catastrophic stroke, which ended up leaving him paralyzed on his right side. He came back to Angola April 15th of 25, and with what they call a post and a DNR, do not resuscitate because of the severity of the stroke. He has ended up improving to where the pig tube that was put in for feeding has been able to be removed, but he still requires assistance with feeding. And despite having vigorous physical therapy while incarcerated, he still has right-sided neglect, which requires him to have basically total care. He's not able to get out of the bed without assistance. He does have some left-sided use, but he's not able to balance himself well enough to go from his bed to the wheelchair, from a wheelchair to a commode, or be able to shower himself without assistance. He's also had residual dysphagia, aphasia. He has some difficulty articulating what he wants to say. But during my time taking care of him over the last year, he's always been pretty pleasant, motivated to try to get better. But unfortunately, he's probably reached his maximum physical gain after having a stroke. That's going to require total care for the rest of his life.
Okay, so the feeding tube is no longer required, no peg tube.
Correct, yes.
Okay, I'd like to ask Morton, January 23, his disciplinary report, that was prior to him being bedbound by the stroke. What was the nature of that?
It was for a 3, which is defiance, and a 21, which is an aggravated sex offense. Before that, his last report was in 2009.
So what, that's a 21D, and that I understand that staff or non-inmate. So was that?
On the above date and approximate time, they were making rounds at the gate, the CC gate, when offender Neal smacked me on my rear. So he touched an officer's behind.
Okay. Okay. I just wanted to make sure it was not more involved in that. Okay.
I don't know if he has completed his sexual offender treatment phase for that, and I don't know if you'll have all that, the anger management and living in balance and Bible college as well.
There is no victim opposed in this case. Other members, do you have?
Yeah, I do. I have a couple questions. So his, we note in his record, a mental health level of tier 3. Can you tell us what that requires?
So Mr. Woggs, a psychiatric mental health nurse practitioner, rounds on him on the nursing unit. If I'm not mistaken, I believe it's more depression. I don't know how long they've actually been following him throughout his stay, but since his stroke is whenever I became aware of Mr. Neal at Angola taking care of him, that he would have episodes of I guess, not wanting to, I guess, try to communicate. And I don't know if that was just for the fact that he was having a difficult time trying to articulate what he wanted to. But they are still following him, and they do have him as a medical level of care of 3. Yes, ma'am.
Which means that he's seen how often by mental health?
Let me see if.
Usually every 3 months.
Okay.
Yeah.
That's our, thank you.
Sorry.
Yes, ma'am.
So, his plan, also would be, has Capital Oaks accepted him as well?
Yes, ma'am. They've also said that they would accept him, upon, receipt of his social security card. So, I know JD, surgeon has, applied for all of those, so we're just waiting to get those cards, but they have said they would take both of the offenders.
Because I did hear some conversation by family that it seems as though their expectation would be that he'd go home based on based on what I've seen in the record and on the video and heard today, I believe that a nursing home setting is probably the most suitable place for him.
But, I mean, I could be wrong. I'll have to look at this again, but I want to say per policy with the paroles and all, they go to a nursing facility to continue care. So a nursing home is where we are wanting to send him, and the family can visit there.
Okay. All right, I have no other questions. You're ready to vote?
I have no questions. I'm ready.
I will, my vote is going to be to grant medical parole. However, I want to note it for the record that should Mr. Neal, and I know this is the policy of the department, if his health improves in a way that he begins to be able to ambulate, that he be returned to the custody of DOC. So my vote is to grant to the nursing home, Capital Oaks Nursing Home.
Mr. Tillis.
My vote also is to grant to the nursing home.
All right, and my vote also is to grant to the Capital Oaks Nursing Home Rehab Center in Baton Rouge with the stipulation that Mrs. Ledoux articulated. So thank you so much for the hard work and putting together the packets for us and the videos. We appreciate it. Thank you.
Thank you.
Thank you.
Today it's 10:14.
So I think they made the right move there. You can tell me what you think in the chat, but he needs to be dealt with either by family or by some kind of professional care. I personally would have preferred him to go to family, but either way, it's better than a prison hospital. We dealt with my wife's father who had a stroke with similar symptoms to what they were describing there, and he had aphasia. And if you're not familiar with aphasia, is basically it affects your speech center, and it greatly limits what you're able to say. My wife's father was basically reduced to not much more than goddamn. That was about all he could get out most times, and we took care of him for 7 years. So 7 years of goddamn over and over and over, and it had a different meaning every time. So it's tough. So whoever takes care of him, I hope he gets the care he needs, and I hope that he's able to find peace in his final days, because it is not easy. Okie dokie, let's go back to Judge Simpson.
If you can unmute. Oh, yeah, he's gotta. Can you unmute, sir?
There we go.
Yep. State your name.
Brian Culver.
Thank you.
It is speak to Mr. Culver. Looks like he does want to resolve this matter, but we have not yet reached a resolution. I'll speak to Ms. Zenda to try to get that resolved.
During the matter, May 6, 2026, 9 a.m. Bond will continue. Okay. Thank you, Mr. Culver. Court calls the case, People versus Carlton Cross.
Ellis on behalf of the people.
Ron Brown appearing on behalf of Carlton Cross.
At him. Carlton Cross. I think that might be. Mr. Cross, are you I'm watching some guy, but I don't know if that's him or not. Mr. Cross, if that's you, wave your hand for me.
Yes, sir.
Okay, there. I think that's you. You got yourself. All right. Your name?
Carlton Dion Cross.
All right. Thank you. What are we doing?
Your Honor, I've provided information to the prosecutor's office about resolution on other more serious matters and requested adjournment of this case. I haven't heard a response from the prosecutor yet. Or requesting an adjournment.
Adjourned matter May 6, 2026, 9 a.m. That's the last adjournment on this matter. Court calls case People versus Brandon Davis.
Ellis on behalf of the people.
Ron Brown appearing on behalf of Davis.
Brandon Davis. I got one unnamed person. Mr. Davis, if you are Motorola Moto, wave your hand. Oh, that's you. Okay, state your name.
Good morning, Brandon Hezekiah Davis.
Thank you. All right, what are we doing?
I'm requesting an adjournment so that he can clear his license and avail himself of an.
Don't have time for that.
That jury then. Final settlement jury, please.
Jury final settlement conference. June 5th, 2026, 9 a.m. Jury selection, June 8th, 2026, 8:30. Both of those proceedings are in person.
Thank you.
Thank you. Court does call the case People versus Michael Elkins.
Ellis on behalf.
Ron Brown appearing on behalf of Mr. Elkins. My information is that he's in the Lenawee County Jail, Your Honor.
You being able to verify that, or we don't know?
That's the information my office had received.
Okay.
If you want to pass it, I can check.
Well, why don't I do this? Because that way he'll be brought to us. I'm going to issue a bench warrant. Bond $5,000. I'll give a 10% privilege on that. That warrant will issue immediately. So if he's there, you can let us know. Thank you. Court calls case People versus Ron Foster.
Ellis on behalf of the people.
Ron Brown appearing on behalf of Javon Foster.
Oh, there he is. Sir, state your name. Oh, you muted. Oh, there you go. Still can't hear you. You don't have earbuds in, do you?
Can you hear me now?
Yes, we can hear you now. Thank you, sir. Name?
Can you hear me now?
Yes, we can hear you. Can you hear us? That's silly to ask. I don't. Mr. Foster, can you hear me?
Hello?
Can't hear him. Can you send him a message? Were you looking to adjourn this?
Set jury.
Hello?
You got it coming through here.
Hello?
Hello, can you hear me?
Yeah.
You can hear me now?
Yes, sir.
State your name.
Javon Foster.
Thank you. Jury final settlement conference in this matter will be June 5th, 2026. 9 a.m. Jury selection, June 8th, 2026, 8:30. Both of those proceedings are in person. Bonds will continue. Thank you.
Thank you.
Court calls case People versus Derek Simpson, no relation.
Ellis and on behalf of the people.
Oh, you're long lost, Mr. Mack.
Always a pleasure, Judge.
Yeah, I wish I could say the same. Listen, no, we got your message. You were caught in traffic.
And Judge Perry. And I must say, Judge, well, perhaps off the record, she knew I had to come here, right? Found out what court it was. I said, well, can I get out early? She said,
Okay. I'll talk to Judge Perry, but that's fine.
no, I mean, that's just my impression, Judge.
Okay, but thank you for being a snitch. Okay.
Always.
Okay.
Well, Your Honor, unfortunately, I've made several calls. I'm not here. I have reached out. I've written with Simpson. I've left messages for him. I've texted. I've emailed Mr. Simpson, and I have simply had no contact with him other than maybe about a month ago, trying to get a phone, and he would contact me. I've left a message with his grandmother. So I don't have an excuse, Judge, why Mr. Simpson is not here.
Bench warrant will issue bond $5,000. Give a 10% privilege. I'll issue that warrant immediately.
All right.
That was out.
All right.
Came in off a warrant recall.
Yes, and I wanted to talk to you about that because he didn't show up before and then had a warrant. So he must have come in and gotten your permission.
Right. We have a warrant recall, so we reset it to today, and then he's not here today.
Okay. All right. All right.
Thank you.
Thank you.
And actually, it is a pleasure seeing. I was remiss in saying. Sure. All right. Court does call the case People versus Liam Hall.
Your Honor, Dan Garrett on behalf of Mr. Hall. I was behind Mr. Mack in Judge Perry's court, asked him if I could go first, and he said no to me.
Oh, did he? Okay.
We got a trickle down effect here. Go.
Yeah, kind of left that out, did you?
Uh-huh. Get your name with. Michael Hall.
Wait, everybody's a snitch today.
Yeah.
All right.
All right. Your Honor, for arraignment purposes, we'll waive reading this.
Defendant having waived from a reading standing mute, court will enter a not guilty plea.
Oh. I'm good.
Go ahead.
Sorry, Your Honor, I know the bond's going to be addressed. I am asking for an adjourned pretrial to review discovery.
Trial in this matter will be adjourned. May 6th, 2026, 9 a.m. And as to bond the alleged BAC in this matter?
0.226.
0.226.
Correct.
I will set the defendant's bond, $25,000 personal recognizance bond. All other standard conditions, including no assault behavior or possession of any weapons. You understand that, sir?
Yes, sir.
There's also to be no possession or consumption of any alcohol, recreational marijuana, or any illegal drug. You understand that, sir?
Yes, Your Honor.
I will also order that the defendant is to report to the Department of Community Corrections for placement on a sober link tether with 3 times per day testing. All right.
Thank you very much, Your Honor. I'll send him over right now. Thank you.
All right. Court calls case of the People versus Sincere Godwin.
Prosecuting officer, Sincere Godwin.
Sir, state your name.
Sincere Godwin.
All right. What are we doing?
I'm requesting an adjournment, Your Honor.
I have no more time.
Set final settlement jury select.
Final settlement conference will be set June 5th, 2026, 9 a.m. Jury selection, June 8th, 2026, 8:30. Both of those proceedings are in person.
Thank you, Your grandmother.
All right. Bond will continue. Thank you. Court calls case People versus Tony Gomez.
Alex on behalf of the people.
Ron Brown appearing on behalf of Tony Gomez.
This is who we're looking for. Veterans Court, I thought.
Dearborn.
They haven't done anything. All right.
I've played numerous calls to my client.
Bench warrant will issue for defendant's failure to appear. Bond is set at $7,500. 10% privilege. That warrant will issue immediately. Court calls case of the people first. Maya Hall.
Alex on behalf of the people.
Running the portion of Police Assistant Public Defender on behalf of Ms. Hall. Ms. Hall, please state your name for the record.
Nia Hall.
Okay. Thank you, Judge Luck. Our office did have communication with Ms. Hall. We are trying to reach a resolution. We have not yet done that. We're asking for an adjournment more time, Your Honor.
Adjournment. And the matter to May 6, 2029, and bond continued.
Your Honor.
Thank you.
I have a question.
Yes, ma'am.
I'm a graduate student at Michigan and I'm proctoring an exam that day. I'm wondering if there's a way that I can come, I think either later in May or if I need to submit something.
What's the exam in?
It is in education.
In education?
Yes.
Education at Michigan? Really?
Yeah.
Really? I don't know. That sounds like, I don't think that's real.
It might not be Maryland, just it's pretty good.
What?
It might not be as good as, you know.
Well, it's not as good as Maryland. I didn't know they had, they got graduation.
Yeah, they have it.
Graduate program.
I'm told they do.
Oh,
Yeah.
That's what I'm told.
Yes.
I didn't know that.
Who
Yes,
knows?
we do.
You know, you're learning something every day.
Yes.
Okay, she wants. What are you going to be when you grow up?
A professor, hopefully, sir.
Wow. I did that for a while.
Okay.
No.
No. Oh.
All right. All right. Okay. Sensei whole class May 6th.
Thank you.
Will May 20th work?
Yes, that will work.
All right. Okay, young lady. We'll adjourn it to May 20th, 2026, 9 a.m.
Thank you
Thank you,
so
Judge.
much.
All right. You're welcome. Thank you. Take care. Court calls the case.
All right, let's change it up, my friends. Go back down to Texas and see what's up with Judge Stevens again.
An attorney to represent you here in an indigent fashion. That is, I find that you were unable to afford one, and we'll get somebody to help you on this. You didn't add up your expenses and your assets. I'll do that for you. Okay. You know, your expenses outweigh your assets. So you're in the dark, you're in the negative, which is why we're going to help you. But what are you doing about that? You can't be just losing money every month, right?
I am.
But you are. Well, okay. How do let me ask this, the father of the children doesn't provide anything?
No, Your Honor.
What have you done about that? Have you done anything to try to?
To see about child support.
Yes, ma'am. What did they say?
I got a paper in the mail the other day that they're opening accounts.
Okay, good. All right. See that through. Okay. 'Cause
Yes.
Two people are responsible for a child generally, and they're going to be held responsible on my watch. Okay. Because it's the way it's supposed to be. Okay, get a resetting here, and what do we want to do on you? Can review? A review, and how long do you think?
3 or 4 weeks just to give the new attorney time. 4 weeks is fine to give the new attorney
Okay,
time.
and we'll get
this
somebody
over.
appointed to help you. I see somebody right there that's a real capable man. Mr. Adams there.
Oh, Rick. Oh.
When he's not sleeping, he's he takes care of his business, and he's got a lot of he's a great success, and we're lucky to have people like him to help folks like you.
Thank you.
It's Mr. Adams, football, sports athlete, a great athlete from Port Arthur, where I was born, and
I'm Renee, pretty good working telephone number.
We ran track. I never knew what he looked like in the face. I could always recognize him from the back because I ran fast, but he's faster. Actually, his son is a better athlete. All right.
You absolutely.
That's what Langston says. His mother's a gifted athlete. He blames his son's athleticism on his wife, who I understand is a very lovely lady who's a great athlete too. But Langston's fine. Thomas Baker.
Next to you.
I don't believe Mr. Baker's here.
Well, let's see. Thomas Baker, 25 CR 1807 is called.
That's fine.
There is no answer in the courtroom. I asked the bailiff to call into the hall for Thomas Baker.
What?
This is 25 CR 1807. This looks like is this an initial appearance, Langston?
Last
Can't
time
tell if there's nothing checked off here.
the last court date we had, I don't believe it was a show.
The medical PR box.
Nothing.
Yes. All right, there is no response to Thomas Charles Baker here in the courtroom. No response to that name, Thomas Baker, in the courthouse, in the outside area, outside the door, in the hallway. In cause number 25 CR 1807, Mr. Baker is charged with the 2nd-degree felony of burglary of a habitation. And there are 3 prior convictions that are alleged as well in this indictment. He is facing habitual felon status, no less than 25 years in prison, up to life imprisonment. He has failed to appear. A warrant shall be issued for his arrest, no bond, since he is unable to be found. When he is discovered and found, placed into custody, then we'll bring him up here and discuss why he failed to appear and what we can do to ensure that he will appear in the future. Hakeem Richard, please. 25 CR 1247. Hakeem. And we've got clients here too. Huh?
Yes, Judge.
All right, you are Mr. Richards here in 25 CR 1247, and Mr. Adams is representing you. As you know, you're charged with a state jail felony of evading arrest or detention, but you've got prior state jail, 2 other state jail felony convictions: a burglary, an illegal possession of a controlled substance, and that was out of this court. And I believe those other 2 state jail felonies will up the punishment range. You would be looking at up to 2 years if there weren't other prior convictions, up to 2 years in the state jail. But I believe this enhances it to a 3rd-degree felony punishment. It's a state jail felony punished as a 3rd degree, which means you are looking at no less than 2 nor more than 10 years confinement in prison. You're punished based upon the circumstances of a crime and criminal history. That's the part of the two parts of the equation that's used in under law. That's why it's always good not to commit another crime. Don't commit one to begin with, but if you do, don't commit another one, or else it gets tacked on to higher punishment range for a subsequent offense. Okay, what to do today?
Judge, I informed him of also being 2 years state jail.
You're looking at up to 10 years. Do you understand? Okay. All right. 2 years is the minimum. Okay.
And Mr. Jefferson, I did give you a police report back and all that. After looking at the police report in the 2 years, also do you want that or not?
Also, you're not eligible for probation in front of a jury because you have one or more felony convictions. They're offering you the minimum. Or you can go to trial, and when you go to trial, it's for a jury to decide and you don't get probation.
Why not?
What are we doing?
Probably not. I'll look at it, but.
Well, what we just asked, Judge, is with the state themselves, hospital 1244, and she said she would look at it.
1244. Well, it's my call, right? At the end of the day. But this is his fourth criminal case. He's been convicted. And here's the deal is he's already been convicted of evading arrest or detention. You know, it has consequences. I mean, you're not only committing new crimes, you're committing the same. What do you want to do? Y'all got to decide.
You want 2 years?
Set for trial. If y'all don't make it, just set for trial, no deal. No deal. We'll just we'll let a jury decide. Let's get that thing fast. I want to get that prioritized. Because we're gonna get this thing to trial. And the court's not accepting a deal. You had your chance. Okay, Lace Christian was reset. Brendan Hardy is reset. Then we go to, hey, Brian, Michael Colvin.
Oh, yeah.
Get that on a fast track, please. Then it'll be first to trial. And noted, no deal.
Yeah.
I don't accept it. Nope, he had a chance.
Okay.
What are we going to do on Colton Barrera?
I submitted a dismissal on that motion.
Okay. So what does that mean? He just continues on probation.
Correct.
Is that you?
Yes, sir.
They just dismissed the motion. So anything else that keeps him in jail?
No, but those, I believe he has hard pending matters.
Okay, well, in this case, the motion was dismissed. You're still on probation.
Yes, sir.
Okay, here, thank you. When it gets to me, I'll sign it. That's all we need. Taylor Jackson. Next. Whoa. 5 cases? Remember, shorten the day. Two, 3, 4, 5. Well, these, of course, are most serious. I'm looking at 24 CR 2260. You're charged with the first degree felony of aggravated sexual assault of a child, which carries with it up to life in prison. 24 CR 2261, another aggravated sexual assault of a child. which again is a punishment range up to life in prison. 24 CR 2262 is another indictment for aggravated sexual assault of a child younger than 14, which carries with it the life in prison. 24 CR 2263, a fourth aggravated sexual assault of a child, which carries with it up to life in prison. And then we have a state jail felony, unauthorized use of a motor vehicle in 25 CR 77, which carries with it up to 2 years in the state jail. So, yeah. 4 life sentences and sentence up to 2 years as punishment range in these cases. Yeah, it's set for announcement.
Yes, sir. What I'm respectfully requesting is one more announcement. I've been in plea negotiations with Ms. Moore. Ms. Moore is going to make a request to see if there is a possible way to resolve this without trial.
Wait a second, it's a year and a half old.
Well,
It's a year and a half old.
well,
These are supposed to be fast tracked.
Well,
This is,
last
I don't do that.
Last announcement, between last announcement and now, my mother-in-law died and my wife went to the
Look,
hospital. I hadn't had a
but
chance.
it's a year and a half, God bless it.
Well, I mean,
Yeah, and
there's
I
a
hope your
chance to
family is
resolve.
doing well too,
Well,
you know,
there's-
I know them and they're a wonderful family. But how much time do you need?
Just 30 days. It's just-
You got it.
Thank you, Chief. 30.
Fix, yeah, take care of them, obviously,
Thank you, Your Honor.
Yeah, that's sad.
Well, I apologize, but
No,
we're
no,
working- we're working to try to
it's
resolve.
natural. It's nature. I mean, we all deal with that and we're entitled to deal with it, with the family. God bless it.
Thank you.
You got slack with me on that, but here's the deal is, we're gonna reset this for 4 weeks.
Yes, sir.
And is there anything else we need on this? Yes,
sir.
no, from the state, Kenesha, Miss Moore, anything from the state? 4 weeks.
That's fine, Judge. Mr. Lane came with me with the counter offer and I told him I needed to speak with the complainant first and I will let.
Here's this. Okay, thank you.
Thank you, Judge.
Need a resend. By the way, the defendant has, you can't contact any of these, even though there may be relatives, family. You're not allowed, nor anyone on your behalf, to contact them. Do you understand?
Yes, sir.
If I find out it would be within seconds, I would order your arrest and there would be no bond. Because on the allegations are bad enough. We don't want children, which happens sometimes, to be where there are attempts to manipulate them during the course of cases pending as it's pending. And that gets people into big trouble. And Arnie Koenig. Here's, thank you.
I can swear the defendant in.
There's Arnie.
There's Arnie. Here's one.
Raise your right hand for me. Do you swear or affirm so that the whole person nothing but the stuff you got? Okay, each of your right thumb print, right thumb. Place it flat on the box. I'm gonna need to wait on. Okay, right outside the box. Okay, let's get one more. Place it right next to it. Okay, that's good. You guys need to judge.
And we now call 24 CR 2327, the state of Texas versus Arnie Koenig. Is that you?
Yes, sir.
Sir. And you are here with your attorney, Mr. Lane, and the state's attorney. Does the defendant waive the formal reading of the indictment and the arraignment here? And we proceed in summary.
We waive the formal reading and we can proceed.
Let's see what the plan is. Okay.
Judge, we are proceeding on the lesser of a class A misdemeanor of attempted
And
burglary.
then the other priors aren't being dealt with then?
Yes, Judge.
Class A misdemeanor of attempted burglary of a building?
Yes.
Okay. Write that. It says attempted. Something.
It is written.
An attempt is, something was attempted. All right, in summary, paragraph 1 of this indictment alleges that on or about September 1st, 2024, in Jefferson County, Texas, you committed the state jail felony of burglary of a building. Do you understand what you were charged with here, sir?
Yes, Your Honor.
There's an agreement that's been reached where you would be prosecuted and you would be admitting responsibility for the lesser included Class A misdemeanor of attempted burglary of a building. Is that right, everybody?
Yes, Judge.
Which carries with it up to 1 year in the county jail and or a fine of $4,000. Do you understand the punishment range applicable?
Yes.
Agreement has been reached that you would be sentenced to 90 days in the county jail. And there is no restitution or loss here.
No, Judge.
Is that your understanding of the agreement?
Yes, Your Honor.
If I follow this agreement, you have no right of appeal.
Yes.
How do you plead to this, guilty or not guilty?
Guilty, Your Honor.
Are you pleading guilty voluntarily and because you are guilty?
Yes, sir.
Show you what's marked as State's Exhibit 1. Did you sign that document? Understand it, discuss it with your attorney, or the contents all true and correct?
Yes.
State's Exhibit 1 is tendered into evidence without objection admitted. Among other things, this states you are mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You were guilty of the crime charged. And in this case, it's applicable any lesser included offenses, such as what you pleaded guilty to, the attempted burglary, a Class A misdemeanor. You are giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses, totally satisfied with the representation provided by your lawyer. All of this is true at state, so help you God.
Yes, sir.
State's Exhibit 1, part of the record for all purposes. Pre-sentence report is waived.
Yes, sir.
I'm going to follow this agreement and find that you are mentally competent to enter your guilty plea to this lesser included offense of attempted burglary of a building. And you were mentally competent to do so. You understand and appreciate the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt. I now find you guilty beyond a reasonable doubt of this lesser included Class A misdemeanor of attempted burglary of a building. I'm following this agreement. You are hereby sentenced to confinement in the county jail for 90 days, and you will be given credit for all time you have served. You probably know where that is, how much that is, but
62 days.
He's at 60?
62, yes, sir.
Okay. Do you understand what has happened today, sir?
Yes, sir.
Okay, anything else?
No, you're-
Okay, that is all. Thank you.
Thank you, Judge.
On Cope and Barrera, there is a motion to dismiss before the court. I'm signing that.
I submitted another one of Gregorio Flores as well.
Alrighty, friends. Well, he's between contestants. Let's switch it up. We'll go back to Judge Aquilina. And Judge Aquilina is muted, so let's see if we can bump this forward a little bit or a little bit in the Wayback Machine.
Guilty of perjury.
Yes.
Thank you. You put your hand down. Have you taken any medication yesterday or today?
No.
Are you supposed to be on medication you're not on?
No.
Any sign of fever, COVID, or other illness?
No.
Have you had an opportunity to speak with Mr. Fidelson?
Yes.
Now, Mr. Palmer, you had him for a plea,
Yes.
and he has since moved on to a higher position in another county. So you have Mr. Fidelson. Are you all right with that?
Yes.
All right. Then counsel, I'm going to add that Mr. Palmer was here for a plea, and Mr. Fidelson is here for sentencing throughout the report. Any objection?
None on behalf of the defense, Your Honor.
No, Your Honor.
I've changed on the cover page, basic information sheet. I don't see it in the evaluation plan, and now I'm moving on to
Your Honor,
events. Yes?
It is on the top line of the evaluation plan on page.
Oh, I totally missed that. All right, thank you. And then moving on to the sixth, is the offense. Says attorney present, so we don't have names. So I think we're good. Any other corrections, additions, deletions?
Not to the body.
None to the body, Your Honor.
Thank you. Do we have any victim who wishes to speak?
I don't believe so, Your Honor, but I do have some changes to the guideline.
All right, thank you. And what about to the body?
Not to the body, Your Honor, just the guideline.
Yes, the guidelines.
So PRV 5 is currently scored at 10 points. I believe it'd be appropriate to be scored at 2. I've talked to defense, and defense is in agreement in regards to that.
That's correct, Your Honor.
PRV 5 is 2.
Your Honor, additionally, OV 10 is currently scored at 10 points. OV 10, Your Honor, is in regards to the vulnerability, the exploitation of a vulnerable victim. It's currently scored at 10 points. However, I believe it should be scored at 15. 15 states that predatory conduct was involved. Predatory conduct is defined, Your Honor, as pre-offense conduct directed at a victim or a law enforcement officer posing as a potential victim for the primary purpose of victimization. And Your Honor, if you read the
description of the offense narrative, it explains that the defendant in this matter, Mr. Theodoro, actually provided the victim with controlled substances as well as alcohol at the time of the incident, marijuana and alcohol. And this ultimately ended up with her being intoxicated and falling asleep and awaking with the defendant being on top of her. Your Honor, I would argue that that shows predatory conduct, so I believe that OV 10 should be scored at 15.
It also, the report included that she had consumed alcohol and marijuana she got from the defendant.
That was my argument.
Both of them, yes.
Judge, I'll leave that to the court.
It is 15.
Additional,
yeah, more changes?
One more change, Your Honor. OV 12 is currently scored at 0 points. That is for contemporaneous felonious criminal acts. I believe that OV 12 should be scored at 5 points. There was an additional charge, Your Honor, of accosting a minor for immoral purposes. That is a crime against a person, so I believe that OV 12 should be scored at 5 points.
Mr. Biles?
No objection to that, Your Honor.
OV 12 is 5. What is the new total for the PRV?
Total PRVs are 12.
Is that a level?
That would not change the level.
All right, thank you.
And total OVs is 45. And that does not change the guidelines either.
All right. Did you have any additional corrections?
I did not, Your Honor.
All right, let me change the basic information sheet, please. I've changed basic information sheet. Let me look under the recommendation narrative. The recommendation narrative scores OV 10 at 10, mentions it, and I'm going to change it to 15. All right, I think everything's consistent. Anything further, or is there anyone to speak?
I will double check again, Your Honor. I did check prior to this case being called. Are Leah or Andrew here and wish to testify? No, Your Honor, there is no victim present wishing to make a statement.
I'm looking at Zoom. I also don't see any of the names. All right, thank you. On behalf of the people, what would you like me to know?
Yes, Your Honor, I believe the recommendation is appropriate given the circumstances of this case. This is a case where Mr. Theodoro took advantage of someone that he considered like a daughter to him, gave this individual, gave Aaliyah drugs and alcohol in order to sedate her and abused her, Your Honor. This is, I do not know what was going through Mr. Theodoro's head, but I do believe that a sentencing of 60 to 180 months at Michigan Department of Corrections is appropriate given the circumstances of this case. Thank you.
Counsel?
Yes, Your Honor. The agreement was for 60 months, Killigrew sentence at the minimum at the time of sentencing, Your Honor. I know probation is recommending 60 months. I would ask that that be adopted. I think he understands the poor choices that he made here. It's gonna obviously have to take his time and register as a sex offender for the remainder of his lifetime. I think he understands all those things and is willing to do the necessary steps to learn from his poor choices here, Your Honor, and ask that the agreement be followed today. Thank you.
Sir, anything you want me to know?
No.
Says it all, kind of, doesn't it? Not even an I'm sorry to the victim. I don't want you to say anything. I would hope that when you ruin a young girl's life, you give her alcohol, marijuana, and have sex with an underage minor who cannot give permission, that you would at least be remorseful.
On my behalf, I really didn't do that.
Then why are we here, sir?
Because I didn't have confidence with my lawyer to take it to trial, so I took the plea.
So you had an excellent lawyer, you have a good record made at the plea. You had a right to go to trial if you thought you did not do anything wrong.
If you read the full report, she also gave 3-4 different stories, changing her stories, and then she was defending me in the first story. I feel like somebody convinced her to say what she said.
She's 15.
That's,
I understand how you feel, but I can tell you that Mr. Palmer has no qualms about going to trial. No qualms. So you can blame your lawyer, but that now is an appellate issue. I've heard nothing in regard to a reason to withdraw a valid no contest plea. So just proceed with sentencing. Let me just read for you into the record. It was reported that defendant supplied her with alcohol and marijuana in the past. The victim stated she was sitting on the couch and she was consuming alcohol and smoking marijuana that she got from defendant. The victim reported being very intoxicated and fell asleep on the couch. She was awoken by defendant being on top of her. The victim reported she attempted to get him off of her, but she couldn't. She again recalled feeling very tired and that she could feel him inside of her. Later defined as his penis was in her vagina. The victim reported being very scared and she did not know what was happening. She just wanted to go back to sleep. The following morning, she had a stomach ache and was throwing up. In addition, defendant reported that if he was to be released from jail today, he would be homeless and he has no contact with his family anymore. There are other parts that might be worthwhile reading, but you certainly took advantage of her family and the 15-year-old. There is no evidence in front of this court to not believe her or to withdraw the plea, so I will not be doing that. It does appear that you have behaved during this time between plea and sentencing, so I will honor the plea agreement. You are remanded to the Michigan Department of Corrections for 60 months to 180 months with credit for 654 days served. You will pay a crime victim's assessment in the amount of $130. I'm waiving fines, costs, attorney fees. You are indigent for that. You will pay a $68 state cost. As for restitution, I've heard nothing requested in restitution. However, you will pay for a transcript of the plea and sentencing so that it will be provided to the guardian of the victim for use during her treatment, therapy, and to address her emotional needs so she understands what happened in this courtroom and that she was heard and believed. I am not surprised that she is not here. While you're incarcerated, you will undergo sort of treatment and training. You will undergo any other mental health treatment that is deemed necessary. Including cognitive behavioral. You will participate in trade school. You have 42 days to appeal and to request appellate counsel. Counsel, please hand me this appellate rights. Do you acknowledge receiving your appellate rights?
yep.
That's all for the record.
Well, that was interesting in all the wrong ways. Let's go back to Judge Stevens. We'll probably finish the day there.
Discovery that we stuff is weird. You have it.
Sir, we're going to ask you to go in front of that lady. She's notary. She's going to swear you in for the proceedings. Thank you.
Where or first, that would prove all proof and nothing to prove self you got. Okay, right them, break them. You can flat on. You can have one more time. Like slide on top of all.
This will close a second.
Which one is?
Judge.
I'm gonna try to take a case that I'm handling for.
Oh. 23 CR 1059 is now called the State of Texas versus Devin Wayne Thompson. That's you.
Yes, sir.
Mr. Thompson, Mr. West, your attorney and the state's attorney. Does the defendant waive a formal reading of this indictment and the arraignment here? Can we proceed in summary?
Yes, please, Your Honor.
In summary, sir, this indictment alleges that on or about March 12th, 2023 in Jefferson County, Texas, you committed the third-degree felony of evading arrest or detention with a motor vehicle. Do you understand fully what you are charged with?
Yes, Your Honor.
If convicted of a third-degree felony, you face a term of not more than 10 years or less than 2 years in prison, and a fine up to $10,000 can also be assessed. Do you understand?
Yes, Your Honor.
An agreement has been reached. In your case, you would be pleading guilty, but not found guilty. You would be placed on deferred or unadjudicated probation, which can be up to 10 years in length. There will be terms and conditions of probation, which are normal and customary for this type of offense. There is no fine here. And right?
Right.
Is that your understanding of the plan?
Yes, Your Honor.
If I follow this agreement, you have no right of appeal of your case. Do you understand?
Yes, Your Honor.
How do you plead to this charge, sir? Guilty or not guilty? Hold on. I did there. Guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily? That is on your own free will and because you are indeed guilty.
Yes,
You have to speak out, so she should say, right, okay. I show you what's marked as State's Exhibit 1. Did you sign that document voluntarily? Understand it, discuss it with your attorney, or the contents all true and correct?
Yes, Your Honor.
State's Exhibit 1 tendered into evidence.
No objection.
And without objection, it's admitted. Among other things, this states that you are mentally competent to enter your guilty plea. It is freely and voluntarily made. You know what you've been charged with. The indictment's been read to you, or you've read it. You are guilty of the crime charged and any lesser included offenses. You are giving up your rights to a jury trial, the appearance, confrontation, cross-examination of witnesses. Totally satisfied with the representation provided by your lawyer. All of this is true. It states, so help you God.
Yes, Your Honor.
States Exhibit 1, part of the record for all purposes. Pre-sentence report waived in this case.
Please, Your Honor. Yes.
I will follow this agreement. If nothing further, I will find that you are mentally competent to enter your guilty plea. It is freely and voluntarily made. There's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt of this third-degree felony of evading arrest or detention with a motor vehicle. But I'm not going to do that. I'm going to defer any finding of guilt and place you on deferred or unadjudicated probation. And this will be for a term standby of 10 years. We will lessen it to 1/3 of that if you do well. You can do the math, that's 3 1/3 years. There will be terms and conditions of probation that you must follow. And if you were sitting here, I mean, here they are, and there are 35 terms and conditions, but almost all of these are requirements of all of us, including you. You know, it's like commit no offense. Well, we better follow that's all of us here. Don't associate with disreputable people. All of us should follow that. Work faithfully, at suitable employment, all of us. Don't use drugs. You know, I could go on, but some of these are restrictive, but for the most part, they are just requirements for living a good life. And please follow those. The probation officer will go over these with you. If you fail and 13 out of 14 people are successful on probation. 1 out of 14 fail, 7%. We don't want you to fail. If there's any question about any term of probation, always speak with your probation officer. They're there to guide you in making the responsible decisions. But if you do fail, your probation could then be revoked. I could then find you guilty and sentence you up to 10 years in prison. Now, one of the terms and conditions of probation that we include is you must complete defensive driving and pay all associated costs. And let me just tell you, don't get frightened about that, because you'll have to pay for the defensive driving course, and your first insurance premium will show you have saved money. It reduces by taking your costs for insurance, which we all have to have, or else it's a crime when we drive. Your cost for insurance will be reduced far more significantly than the cost for that class. In fact, there's some people I know that take it regularly just to keep their insurance down, which is not a bad idea. So that's a win for you. If you're in trouble here, and now we're not only helping you get out of this, but we're saving you money. So follow those terms and conditions and you'll be fine. And then you can get terminated with this within a third of the time. Okay. Any questions you have, sir? Okay, please see the probation officer and good luck.
Okie dokie, friends. That's the logical place to call it for today. I hope you all had fun. I did, at least while I was doing court stuff, not when I was doing tax stuff. But it's done now, so I can go on about my day, so that's nice. But thanks for spending some time with me this morning. I always enjoy getting up and spending my mornings with all of you, so I appreciate it. So much so, let's do it again tomorrow, 9 a.m. Eastern, 6 a.m. Pacific, a half an hour earlier if you are a channel member. If you're not a channel member, I encourage you to join us. Thank you for everything you've done for me today. Go have yourselves a great day. We'll see you tomorrow. Take care. God bless.